No puppy in your leash. I need to be like an actual maker of videos at some point and start using like an intro screen. You know how like streamers will have like a waiting screen? Well, now that's too adjusted. I need to do that at some point instead of just like having the stream randomly start while I'm in the middle of singing a song to myself or something. I probably should work on that. All right, I'm going to check levels. That's probably what people are doing during their like getting ready card things, the little animations they'll have, and like I'm waiting on stream. They're probably doing this, which is checking that the volume levels are right. Card things, the little animations. Okay, start reading.
Individually and as next best friend of her deceased.
Okay, I'm talking while it is reading. How is the audio levels?
Certiorari to the
Need to make sure it sounds good.
Court of Appeal.
Okay, I'm talking while it is reading. How is the audio levels? Need to make sure that's good. That's classically good enough. All right, I'm going to turn off monitoring now. I will be able to see the chat, it looks like, and I am generally able to see me, so I'm going to close my streaming dashboard, and I'm going to start explaining what the rest of the stream is about. Hello and welcome back to The Quiet Part once again. So this is now the third actual stream video in this series of streams that are targeted at reading a particular Supreme Court ruling called Town of Castle Rock versus Gonzales, which was a 2005 Supreme Court ruling in a murder case that was also, at its core, it was about restraining orders and whether or not police forces have an obligation to actually protect people. Are policing systems, do they actually have a legal responsibility to protect people and do their job? And of course, this case found out that the Supreme Court ruled rather insanely that no, police don't have an obligation to literally do their job. The main legal language they depended on was the concept that policing is discretionary here in the United States. It's per discretion, right? Just because a cop sees something illegal happen that actually, I bet most people don't even realize or think this, they just know it intuitively maybe. If a cop sees something illegal happening, it's their discretion whether or not they actually do anything. Like, sure, maybe the police force and their superiors and their internal system might fire them for being too discretionary and not doing their job. But legally, there are no consequences for police officers, not just because of qualified immunity, but because the Supreme Court ruled that police forces have no obligation to actually enforce a restraining order. They have no obligation to actually do anything with it whatsoever, according to the Constitution. It is not a violation of a person's civil or human rights to just not enforce a restraining order, even though you gave them one under the assumption that you would enforce it. That's how the restraining order works. So previously, I read a couple of Wikipedia pages about about the case itself, about some precedent cases, and then I stepped it up to some case briefs, casebrief.com, summaries of the facts of these cases, and then I finally got onto a kind of official publishment PDF of the Supreme Court opinion. But what I ended up reading, and I realized this as I was reading it, that it was just too short. Something wasn't right about the document I was reading. It seemed weirdly short, and it didn't tell you which justices were taking which positions. It didn't consistently tell me like, oh, you know, here's the concurrence, here's the majority opinion, and then here's the dissent, and here are the people talking. It would just kind of mention them retroactively, and it only occupied 20 pages on the actual PDF document I was reading from. And so after I finished those 20 pages, and I had failed to beat Minecraft in a speed run in the process, as you can see here, I went back yesterday or the day before, and I was like, man, something seems wrong. I feel like I didn't get the full document. And it turned out to be true that I did not get the full document. I have now gone to the Library of Congress, and I have found the complete full-length opinion document, which is closer to 45 pages or something, if I remember. Even though I've read many direct paragraph-length quotes from this document already, I'm just going to read through this one again so I have the absolute best view. And honestly, I was struggling to really comprehend the document in the last stream. I think I was focusing too hard on Minecraft, which I will also do in this stream too. So, hey, I'm going to read it again, essentially. But this time, I'm going to get a much more fleshed out version of the dissent specifically. And the dissenting party, which I believe this was something to 2, 5-2, something like that. There were 2 people that disagreed, 7-2. I don't remember. But somehow the vast majority of the Supreme Court agreed that police have no obligation to actually protect citizens, which is insane. But yeah, we're going to be reading through this document. I'm going to read it a bit faster because I will have read parts of it before, but I'm also going to be trying to speed run and finish beating this Minecraft world, which last time I only got like 3 or 4 hours into playing this particular seed that I'm doing well on right now. So there's a chance I might beat it. And there's a guaranteed chance that I read through this document and learn a bit more. It is now linked in the description below this live stream, but what's up?
You know where the drill is?
No, not really. Could you grab me a water bottle?
Yeah.
I don't know where the drill is. It should be downstairs. It's over near the 3D printer, probably.
I didn't see it either.
Oh, great.
I'll look again.
That's like the only 2 places I put it. Yeah. I don't think it's in here.
You don't think so?
Mm-mm. I haven't really drilled anything in this room other than those. Okay. Disregard that. So yeah, we're gonna read through this document. We're gonna keep speedrunning Minecraft. We're gonna focus really hard on the dissent so we can rekindle just a millimeter of hope in humanity. And if I remember correctly, the 2 goats of the Supreme Court through my lifetime, Justice John Paul Stevens and Ruth Bader Ginsburg, are in the dissenting team, which means you know they're probably right. Because if those 2 are teaming up, it's over. All right? It's like Yuji and Togo in Jujutsu Kaisen teaming up. Like that's the ball team. Yeah, of course the ethical, moral, human people are the ones that were in the dissent in a ruling that said that cops have no obligation to protect and serve. Like what? Yeah, of course. Craziest thing I'm learning as I keep reading about the Supreme Court. Number 1, a reminder to myself, just use Library of Congress documents. The Library of Congress will never do you wrong. Just use that. I'm going to use that for my Supreme Court opinions from now on. You can see that, like, even though this is the first page of the PDF document itself, it says page 748 because the Supreme Court publishes, like, to archive their Supreme Court opinions, they put it in a report document that is like hundreds of pages long, and it has many, 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 many cases and decisions and opinions in it. Those reports, I found the Supreme Court's official website for those reports, but their system for navigating them is horrific. So Library of Congress is going to be the way to go for myself moving forward. And I just need to freaking memorize that because I keep forgetting that is where the best place to find correctly formatted full-length Supreme Court opinions is going to be located, the Library of Congress. So I think we're going to get going. We're going to rehash a lot of what we already read. We're going to learn and see some more kind of human writing actually this time, as it won't be cherry picked and condensed in the same way. We'll get to kind of see people as lawyers, as judges, and as people build their arguments instead of it being kind of so cut and dry the way that the shortened document we read last time was. And if I miraculously cannot beat Minecraft in the next 2 hours, which I guess I might not, and I somehow get through this 46-page document, then maybe we can read through the oral arguments that preceded these opinion documents, and we can kind of get an even more human look into how this debate went in the actual Supreme Court itself. I was going to mention, in the description of this video now, and likely in whatever video I make out of this live stream eventually, there is a link to a documentary called Home Truth, which is a documentary about the woman who is at the center of this case, and the loss of her children, and the life she dedicated to fighting this fight for women and for justice. Incredible documentary. I really wanted to show it on stream, but I thought about how some real people in my local community put that documentary together. It's all Denver and Colorado and Castle Rock and Boulder people that built this this incredible documentary. You can get it for free with your library card. And if you're an educator at a college or a high school and you want to show this documentary, I deeply recommend that. This is incredible. It's filmed wonderfully. It has important context. It tells an incredible story that is relevant to politics and culture and history and theory and really good. And it's a good length. It's like an hour and 10 minutes or so. You can buy it for like educational and professional use. It's like a few $100s depending on what institution you're at. But I encourage any educators to definitely consider buying it for your classroom, because it would be an incredible investment that you could show every year for the next 3 decades, and it would never get old because it's so relevant and so powerful. But you can watch it for free if you have a library card here in the US. I used my library card to watch it for free. It was incredible. But I'm not going to show it on stream because I just don't want to disrespect the work and the ownership of these people by showing it and doing lazy react content. I think what I will do is edit some scenes of it and talk about my experience of watching it retroactively in whatever video I make on this topic. Okay, I think I've said pretty much everything that needs to be said for the actual video itself, and the stream and giving full context. Not that like a summary of what I'm doing isn't down in the description for this video and this stream, which I will try to make a habit of moving forward. Let's play Minecraft and let's start reading. So this is going to be just this Supreme Court ruling opinion. It's pulled out of a larger report, and this is just the opinion for the case of Town of Castle Rock, Colorado versus Gonzales. Let's go ahead and read. I might slow it down and speed it up. I might pause it. I might, do this and that, but who knows? Yeah, let's get to it. Cool.
Appeals
Minecraft
for
time.
the 10th Circuit.
Here we go. Yeah, it's reading a bit.
Note
Reading
for
faster is almost a little bit easier for me to
0478.
understand.
Argued March 21st,
Oh, this is not the
2005. Decided
right world.
June 27th, 2005. Respondent filed this suit under 42 U.S.C. Section 1983, alleging that petitioner violated the 14th Amendment's due process clause.
I wonder if
when
did I
police
lose the
officers,
speed run?
acting
That would
pursuant to
suck.
official policy or custom,
Did I
failed
lose
to
the
respond
world
to her
that the speed run
repeated
was in?
reports over several hours that her estranged husband
Well,
had
that would
taken their
suck.
3
I would
children in
restart and I would get
violation
over
of a
it, but
restraining order against him. Ultimately, the husband murdered the children.
9525.
The district court granted the town's motion to dismiss, but an
let's
embanked
see.
majority of
Was
the
it
10th
this?
Circuit reversed, finding that respondent had
No,
outright
this is my
cognizable
old-
procedural due
old
process
stream.
claim because
I
a
think I might have
Colorado
lost
statute
my world.
established the state legislature's clear intent to require police to enforce restraining orders, and thus
I
its
thought this
intent
was
that
it.
the order's recipient have
This
an
is just sending me
entitlement to
somewhere
its
random.
enforcement. The court therefore ruled, among other things,
I think
that
I lost my
respondent had a
speed run.
protected
I guess I'm
property
okay with
interest in the
that.
enforcement of her
I guess I don't
restraining
mind.
order.
What matters is reading.
Held, respondent did not, for due process clause purposes. have a
Fuck it. I
property
think I'll just
interest
start a
in
new
police
speed run then.
enforcement of the restraining order
I've got
against her
46
husband.
pages. That's twice as much time as last time.
755 to
I'm going to slow it down
768.
so I have a better chance. Fine. Yeah, we're just restarting.
Due process
We're restarting the whole
clause's
concept. I'm fine with
procedural
that.
component
All right,
does
let's
not
make a bunch of
protect
worlds
everything
and
that might be described as a government benefit. To have a property interest in a benefit, a person
okay, I'm going to delete
that
some of
must
these worlds I already
not have
made.
a legitimate claim of entitlement.
This is almost definitely how
Board
I
of
lost
Regents of State
the
Colleges
previous speed run.
versus Roth,
I'm going to keep this one because it's
408
special to me.
U.S. 564.
All right, so I'm hearing the same things. I'm hearing some terms that I struggled to define last time I tried this little challenge. I guess we're fully restarting. Can I beat Minecraft before reading all 46 pages of this? I don't know. We're allowed to generate new worlds until we find a seed that's preferable. One that has a village and other good stuff nearby. And I'll just keep going and restarting until I figure it out. But I'm seeing the same fundamental concepts. There's a lot of talk about the 14th Amendment and how the 14th Amendment of the U.S. Constitution prohibits the government from interfering with a person's life and liberty and their property. And in order to make this case about a civil right, the mother who lost her children when the police failed to enforce the restraining order and ignored her for like 10 hours of phone calls, which is horrifying. She held, I'm just reading what I'm seeing by accident. She argued that she had a property interest in the enforcement of the restraining order because the government gave her a restraining order, which is a piece of paper that has a meaning. And she's like, yo, you made this my property. You were the government. You made this my property. You made me a promise that you would restrain this person. I called you several times when he picked up our kids and didn't tell me beforehand, even though he might have told me after. He didn't tell me beforehand. He didn't respond to my calls. I could not find my children. They were kidnapped by my husband, who I have a restraining order against. the argument she had to make, her lawyers had to make, because of the way the Constitution is written, is that the restraining order was a piece of property that was given to her by the government. And according to the 14th Amendment, the government has no right to interfere with a person's life, liberty, or property. And the government gave her this property, this restraining order that was supposed to mean something, and they failed to do their job. They interfered with her property, and arguably her children's life and their liberty and freedom by allowing them to be killed. The Supreme Court ruled, of course, that a restraining order is not a true piece of property, and she's not obligated to the police. Actually, constitutionally, they ruled that she's not obligated to the police enforcing a restraining order, making them worthless, like just worthless. So that's absolutely fucked up.
564.
All right, let's start generating worlds. I can't believe I lost my old speedrun. No,
Such
whatever.
Entitlements are created
You let
by
stuff go and move on.
existing rules or understandings stemming from an independent source such as state law. E.g., IBID pp. 755
Oh, that was.
to 756.
I'm an adult. I'm not gonna laugh at that. Oh, there's a lot of iron here. If there's a village nearby.
A benefit is not a protected entitlement if officials
Let me
have
increase
discretion
my
to
render
grant or
distance like
deny it.
insane.
C.E.G. Kentucky Department of Corrections versus Thompson.
So I don't know all of these
490
precedent Supreme
U.S.
Court cases. I just know the super relevant one where they ruled
462
previously
to
in something versus
463.
Winnebago County,
It
I
is
think.
inappropriate here
I can't
to
remember
defer
exactly
to
what
the
that
10th
case is,
Circuit's
but
determination that Colorado law gave
responded
respondent
a right to police enforcement
of
of
the
the restraining
restraining
order.
order.
Isn't appropriate here.
This court therefore proceeds to its own
So a previous court
analysis.
said that, hey,
PP
this person has a right to the restraining order being
756 to
enforced.
758.
And the Supreme Court is saying, nah, we get to decide.
C. Colorado law has
Kinda
not
fucked up.
created a personal entitlement to
Okay, so
enforcement
they're
of
interpreting state law.
restraining orders. It does not appear that state law truly makes
Mandatory.
such
So they're going to
enforcement
argue that even
mandatory.
though like all the language seems
A
mandatory.
well-established tradition of PA.
Okay, policing. Saying the quiet part out loud. Watch this.
545 U.S. 2.
Yep.
Unit.
Oh no, it's
76
going to do
for
this bullshit every time. I'll deal with it.
cases. March 26th,
Wow, now that Minecraft's running better, this looks beautiful.
18 seconds.
But I don't see a village.
PGT,
I'll run a little bit, but
Cite as 545 U.
oh god, the game hits really bad.
748,
Hey, a desert temple?
2005.
Hey, maybe that's a chance. Maybe we can use a desert temple instead of a village. But we're going over there.
749.
Wow, it took that long just to read the headline.
Discretion has long coexisted with apparently mandatory arrest
'Kay.
statutes.
So like second page, and they've already summarized most of this document. They're saying a well-established tradition of policing discretion. Oh, they're saying, and I quote, a well-established tradition of police discretion has long coexisted with apparently mandatory arrest statutes. So they're going to be citing Chicago versus Morales, which I don't know the full context on. What they're saying is that just because the language of legal documents makes it seem like cops have to do their job, they don't actually, because it's discretionary. And how could a police officer ever possibly always do their job? Sometimes they're going to have to let the small stuff go. And then I get that, but that's such a cop-out to be like, yeah, it's okay that the cops ignored this woman while her husband murdered her children. He was on a restraining order and she tried to get it enforced by calling them, going to their office, and trying to set up meetings with them over like a 10-hour period of them ignoring her. So like, fuck you. This is a cop-out and evil. And frankly, if the option is to live in a country where the police are required to do their job and can be sued for failing to, but that means, there's going to be a lot of frivolous cases, which is going to be a strain, and maybe it's going to disincentivize some people to be police. That sounds like a good outcome to me, actually. If the options were that, or living in a world, oh dude, what? This might be huge. I can make stuff. If I get there's some iron up there. You know what? We might have a speed run, boys, on the first run. That's insane. If the options were to live in a world where police are overly scrutinized, but held to a higher standard, or living in a world where there's like no real standard for police, but it means that there's less frivolous lawsuits. Yeah, I would take the world where they have to do their job. I would definitely take the world where they are legally required to do their job.
Utes.
Not that I even like
CF
the existence of
Chicago
policing,
versus
but I'm just talking
Morales.
about real life as it stands right now.
527 U.S. 41, 47, N. 2, 62.
Who thinks I can tank this
32.
fall? I
Against
can.
that backdrop, a true mandate of police action would require some stronger indication than the
There's TNT down
Colorado
there.
statutes.
All right, what do we
direction to
got?
use
What
every
the hell is that?
reasonable means to
Ooh,
enforce a
enchanted
restraining
golden
order,
apple.
or even to arrest
Okay.
or seek a warrant.
Wow, I've
Colorado
got stuff to make
officer
about.
would
This
likely
I
have
might
some
just use this for
discretion
my
to
run.
determine
No
that,
joke.
despite
I really
probable
might.
cause to believe a restraining order has been violated, the violation circumstances or
Okay, you know what? I can make
competing
basic leather
counsel
armor with this much
decisively
leather, so
against
that's something for me.
enforcement in a particular instance.
No, wait, this is kind of
The
tough. Like, this is a
practical
good outcome
necessity for
overall. Now, the
discretion
issue is I
is
didn't go grab any
particularly
wood because I'm an
apparent
idiot. I
in a
should have done that
case
if I was
such
treating
as
this more
this,
seriously.
where the
Oops.
suspected violator is not actually present and his whereabouts are unknown.
Okay, so I read this previously too, where
In
it's all
such
about like, oh,
circumstances, the statute
they don't
does
know,
not
they couldn't
appear to
find him,
require
so how are they going to
officers
enforce a
arrest,
restraining
but
order? By
only to
looking,
seek
you
a
fucking
warrant.
idiots. By looking.
That,
That's your job. You have like
however,
one
would
job.
be an entitlement to nothing but
Guy's
procedure,
committing a
which
crime,
cannot be the basis for a
and you're just going to
property
like ignore it.
interest.
I'm going to have to eat
EP
some of this rotten flesh, unfortunately.
758 to 764.
Well, I'm getting food out of it. That's
D,
something.
even if the
No joke, I
statute could be
really don't
said to
consider
make
TNT to be that
enforcement
useful.
mandatory, that would
I know
not
that's kind of insane, so I'm
necessarily mean
low-key
that
just going to
respondent
sacrifice the
has an
TNT and not care.
entitlement to enforcement.
I now have to get back up that
Her
mountain because I had
alleged
a bunch of
interest
iron.
stems not from common
And it looks
law
like
or
coal if I remember.
contract, but only from a
So I now have to get back up that
state
mountain
statutory scheme.
and
If she
actually
was
remember
given
where
a
the hell that mountain was,
statutory
because I don't really
entitlement,
remember where it was.
the court would expect to see some indication
Oh, I
of
came
that
from this
in the
way.
statute itself.
It's probably up there, I think. Yeah, I
Although
came from
the
this way.
statute
So I need to
spoke
get
of
back up one of these
protected
mountains.
person, S, such as respondent, it did so in connection with matters
I'm going to need
other than a
trees.
right
That's
to
going to be an issue.
enforcement.
I'm not sure I can make wood blocks out
Most
of
importantly,
sticks.
it spoke directly to the
Can I?
protected person's power
I
to
don't think so.
initiate
I'm going to figure out
contempt
something.
proceedings if the order was issued
Without
in
wood,
a
I'll be
civil
kind of cooked,
action,
so I'll figure
which
something out.
contrasts tellingly
There
with the
is
conferral of a power merely
maybe
to
a
request
freaking village in that direction.
initiation
There's
of
no way.
criminal contempt proceedings,
So what happens
and
if I do
even
4
more
sticks? Nothing?
dramatically with its
That's not
complete
good.
silence
Okay.
about any power to request, much less demand, that an
Okay.
arrest be
Well,
made.
let's climb this again. I can go get
PP
iron.
764 to 766. E. Even were the court to think otherwise about Colorado's creation of an entitlement, it is not clear
there's
that
trees.
an
Okay.
individual entitlement to enforcement
So I need to get out of
a
these. I don't know what this
restraining
biome is
order
called. I
could
think this is called like the
constitute a
Badlands or
property
something.
interest for due process purposes. Such a right would have no ascertainable monetary value and would arise
Cool. But what? I really don't
not
know
out of
what
some new
mountain I was on top of before
SPECs
this.
government benefit or
But wood's going to be
service,
more important for
but
now.
out
I
of
need
a
to go get it.
function that government actors have always performed, arresting
People
people
when
when
they
they
have
have
probable
probable
cause.
cause.
I really wish my game didn't do
A
this hitching
benefit's
thing that it's been
indirect
doing, but
nature
I'm just going to
was
have to
fatal
cope.
to a due process claim in
I'm an
O'Bannon
idiot for
v.
not getting
Town Court Nursing
wood immediately.
Center,
That was stupid.
447 U.S.
Also, I'm just going to double check
773,
the
787.
stream chat. Yeah, no, it looks fine.
Here, as there, T, he simple distinction between government action that
I need to read
directly
all of these
affects a
Supreme Court cases.
citizen's legal
It sucks,
rights
but like
and action that is directed
low
against
key
a
reading
third
like
party
100
and
Supreme, the
affects
100 top
citizen
100 most
only
relevant Supreme Court cases
incidentally.
should like be a
Pro.
requirement to graduate high school. I'm not joking. I really think it should be.
545 U.S. 2.
I mean it. Like less
Unit
history, more Supreme Court decisions,
76
because
Uruguayan
those are what are going to
pesos,
affect a person's life in a
March
material way.
26th,
History
08,
affects a person's life in a material way,
21,
absolutely.
18
Um,
seconds. Pages
But if
PGT,
you know, if I heard someone was
open.
proposing that like it's a requirement for students to read a certain number of cases, I'd
750.
be completely okay with it. I'd be like, do it.
Castle Rock v. Gonzales.
I bet there's a lot of great history teachers that do make students read
Opinion
Supreme
of the
Court
court.
cases, and a lot of them. I'm absolutely certain of
Viewed
that.
as a sufficient answer to cases finding government-provided services to be entitlements. ID
Yeah, I
at
failed to do like the basic
788,
Minecraft thing, which is like just build a few things.
pp. 766 to 768.
All right, let's get
366
some
F,
wood.
3D
Doesn't have to be enough for now.
1093 reversed. Scalia, J. delivered the opinion
Opinion of the court. Yep.
in which Rehnquist,
CJ, O'Connor,
and
Kennedy,
O'Connor,
Souter, Thomas
Kennedy,
is immortal and
Souter,
refuses to die or retire.
Thomas, and Breyer, J.J., joined.
See, I didn't get
Souter,
this last time I was reading the
J.
document.
filed a concurring opinion, in which Breyer, J. joined, post, page 769. Stevens, J. filed a dissenting opinion, in which Ginsburg, J.
Ginsburg.
joined,
Yep, Stevens filed a
post,
dissenting,
page
and Ruth Bader
773.
Ginsburg was it with him on that.
John C.
Huge stuff.
Eastman argued the cause for petitioner. With him on the briefs
I'm
were
not sure what
Thomas
cause for
S.
petitioner means,
Rice,
but
Eric
that's
M.
fine.
Ziporin, and
I'm gonna
Eric
need a
S.
bunch of wood,
Jaffe.
and I need to really
John
genuinely
P.
prepare for that.
Elwood
I ended up needing a
argued
lot in the last
cause for
speedrun.
the United States as amicus curiae urging reversal.
First one.
With him on the brief were Acting Solicitor General Clement, Assistant Attorney General Keisler, Michael J. Sain,
No idea who any of these
and
people are.
Howard
Not a single
S.
one.
Schurz. Brian J. Reichel argued the cause and filed a brief for respondent.
Okay, I'm pretty happy to get such a good world on the first try. I feel like I just saw a
Scalia
village, which will help
delivered the
me.
opinion of the court. We decide in this case whether an individual
Who has obtained a state restraining order has a constitutionally. This is what's going to suck. It's going to cut this off for a sec.
Asterisk briefs of amici curiae urging reversal were filed
I
for
don't
the
need that.
Denver
really
Police
don't need that.
Protective Association et al. By David J.
Super
Bruno
tracks that
and
a
Michael
Denver
T.
police
Lowe,
advocacy
and for the
lobbying group
International Municipal Lawyers
would pull that bullshit.
Association et al.
Oh
by
hell no, I'm
Brad
not going
D.
down there. That's not
Bailey
happening.
and Catherine L. Schroeder.
I think this is where I spawned, but I
Briefs
don't
of
remember.
amici curiae urging affirmants were filed
But I saw
for
a bunch of
AARP
good
by
material
Stuart
over
R.
there.
Cohen, Susan and Silverstein, and Michael Schuster.
This is going to be
for the
annoying reading the
American
footnotes for
Civil
every page
Liberties
out of
Union
order,
et
but I'll
al.
just deal.
By Caroline M.
I think
Brown,
I just tend to kind of
Stephen
ignore
R.
the footnotes
Shapiro,
unless I
and
really
Lenora
hear
M.
something I think is extremely
Lapidus.
relevant.
For International Law Scholars et al. By Jennifer K. Brown and Rhonda Copeland. For the National Association of Women Lawyers et al.
Nope, yeah, this is where I
by
started. I remember
Lily
that tree.
S. Masters.
So I just need to get up there
For
to the exposed
National
rock.
Black Police Association et al. By Richard W. Smith and Joan S. Meyer. For the National.
I just want to go straight to the... Yeah, here we go.
Coalition
This is
Against
such a
Domestic
huge place to have
Violence et
started.
al. By Naomi G. Beer. Libby
Okay.
Y. Moat,
Let's do
and
this.
Michelle E. Stone.
We're going to do this.
For the National Network to End Domestic Violence et al. By Fernando R. Lagarda. And for Peggy
So
Kearns
what
et
I've
al. By
learned since reading the
David G.
documentary and the
Hall
first
and
round of
James
reading
C.
the
Arrington.
documentation on this is that
TNM Ottaviano
oh my god,
and
I hear a
Janine
skeleton. Leave me
Carlin
alone.
filed a brief for the Family Violence
I've learned that this
Prevention Fund et
document
al.
has a
as
lot
amici
of
curiae.
cultural ties necessarily to
545
like a
US
later wave of feminism,
Unit 76
women
Uruguayan
fighting
pesos,
to have themselves be
March
heard,
26,
to not
08,
let their husbands just get off with
21:17
domestic
and
abuse,
18 seconds.
to have restraining orders
Pages
actually do anything,
PGT, open.
stuff like that.
Cite
Just gonna get a
as
bunch of cobblestone for the
545
beginning.
S 748 2005. Opinion of the Court 751. Protected property interest in having
Again,
the
so it's this
police
concept
enforce
called a property
restraining
interest, which
order
is an
when they have
interest in
probable cause
the
to
government not
believe it has
interfering
been
with your
violated.
property.
The horrible facts of this case are contained
So,
in the complaint that
at least the Supreme Court justices pretend to be human. Like, oh, murder's bad. Yeah, and the cops let it happen.
Us on appeal from a dismissal of the complaint, we assume its allegations
Also,
are
let it be
true.
said very explicitly aloud.
See Swire-Kiewicz
Um,
versus
Let it be said explicitly very aloud that this woman's story is horrifying, it's disgusting, it's terrifying, it's evil what her husband did. But there's also an innate evil in the refusal of police to even come and see her when she called them like 5 times over 10 hours, and her children ended up dead because of it. There's an evil in what her husband did. And I know some people are going to have this, probably not people in my audience. Let me be completely real. I expect better of my audience. I need to start saying that. Like, I expect better of my audience. So maybe like a generic average American who has like no political context is going to look at this and be like, this is such a shame. This is horrible. Her husband is the real evil. The murder is the evil. The government, dude, that's just, what does that got to do with it? It has everything to do with it. Even some of the arguments in the document I read before explicitly say like, hey, it is wrong to be like, we've created the police to protect you. And the social contract is that you give up your right to self-defense and murdering people you dislike. But you gain the protection of police. You gain those people being arrested and put into the justice system. So there's a trade. And actually, we have a monopoly on arresting people on violence. The state has a monopoly on violence. And because of that, you aren't allowed to go out and seek it. And in fact, you won't even think to hire private security because your husband is crazy. Because the police are here and we've got you. So there's like an innate evil, deception, insidious, systemic violence built into arguments against Jessica Gonzales, whose name is now Jessica Lenahan in real life, I believe. In modern day real life right now, I believe her name is now Jessica Lenahan. Might have changed again, I don't know. But I don't know. It's evil. The person is evil. The case is evil. The ruling is evil. The system that made this happen is evil. It's all fucked up.
Swire Kiwix versus Sorima N.A. 534 U.S. 506 508 N1 2002.
All right, motherfuckers. It is time
Respondent
to
alleges that
mine.
Petitioner, the town of Castle Rock, Colorado, violated the Due Process Clause of the 14th Amendment to the United States Constitution when its police officers,
Why did it read
acting
Constitution
pursuant
wrong?
to official policy or custom, failed to respond properly to her repeated reports that her estranged husband was violating the terms of a restraining order. Point 1. The restraining order had been issued by a state trial court several weeks earlier in conjunction with respondents' divorce proceedings. The original form
What is
order,
Dune
issued
armor
on
trim?
May
Like,
21st, 1999,
Dune the fucking
and served on respondent's husband on
sci-fi
June
series?
4th, 1999, commanded him not to molest or disturb the peace of respondent or of any child, and to remain at least 100 yards from the family home at all times.
It's kind of nice reading through this stuff again in a way. Like, I'm understanding it better. I'm following it better.
1143.
When I'm reacting to it live, there's a lot of and I mean literally when I streamed this last, there's a lot of me just not knowing what's going on.
The bottom of the pre-printed form noted that the reverse side contained important notices for restrained parties and law enforcement officials.
Ibid.
Emphasis deleted.
I really need to remember what ibid means. Does that mean direct quote, I think?
That respondent's complaint did not allege that she ever notified the police of her contention that her husband was active ally in violation of the restraining
She shouldn't
order.
really be obligated to. The police
Brief
department
for
knows. She
petitioner
called
7
them.
and
People
2.
call the 911
complaint does
because they think
allege,
something illegal has
however,
happened.
That respondent showed
the police a copy of the order.
Copy of the temporary
And requested that
restraining
was
order,
enforced.
TRO, and requested that it be enforced. App to Pet for Cert 126A. At this stage in the litigation, we may assume that this reasonably implied the order was being violated.
Yes, of course. Okay, there's a freaking village over there. What is going on?
Citizens for Better
This is a great seed.
523 U.S. 83.
Oh no, the game is starting to do this thing where it hitches every 3 seconds.
1998.
I think I have some
545
guesses as to why it
US2.
does this sometimes. I think I'm just simulating too
Unit,
much somehow.
76
Even though my
Uruguayan
PC is
pesos.
completely busted and
March
able to deal with it.
26th, 08, 21, 17,
Yeah,
and
300 FPS. I don't know
18
what the issue is.
seconds. Pages PGT.
I kind of think it's my
open.
RAM somehow.
750.
What is this smooth ass jazzy Minecraft
Castle
music I'm hearing
Rock
right now?
v.
This is insane.
Gonzales. Opinion of the court.
Dude, I'm getting full
Printed
full
text
freaking
on the
armor.
back of the
I'm making a
form
shield. I
included
couldn't
the
do any of this last time
following
I played
warning.
in the last seed. This might low-key be a
knowing
better playthrough
violation
at this
of a
rate.
restraining order is a crime. A violation will also constitute contempt of court.
Ooh, leave me alone, zombie.
You may be arrested without notice if a law enforcement officer has probable
Nice.
cause to believe that you have knowingly
I doubt I can
violated
do
his
anything with these
order.
emeralds over here, but it's worth
ID
taking a look at.
at 1144 M faces in original. The
Oh,
pre-printed
it's the
text
wrong.
on the
I need
back
a
of the
steel
form
pickaxe, I guess, for
also
that.
included a
Okay, I want lots of
notice
coal.
to
I want
law
a stupid
enforcement
amount of iron.
officials,
It's really
which
going to be
read in
useful.
part,
You know what though? Here's
"You
the trade-off.
shall
When I get into the
super
Nether,
erase in
I'm never gonna
obedience
find a
to
fortress
enforce
thingy.
this restraining order.
It's just not gonna happen. It's gonna
You
somehow.
shall arrest, or,
The game's gonna balance
if an
itself
arrest would
in
be
terms of RNG.
impractical under the circumstances, seek a warrant for the arrest of the restrained person when you have information amounting to
You know, I
probable
wonder if by
cause that
choosing to read the
restrained
document super
person
slow
has
last time,
violated
because the original
or
document was
attempted to
shorter than
violate
this,
any provision of this
um,
order and the
I wonder if it
restrained
made it harder to
person has been
comprehend, because it's
properly
actually
served
easier to
with a
follow when it's
copy
going a
of
little
this
bit faster
order
like
or
this.
has received actual notice
But
of
again,
the
I can't tell if that's because I
existence
read it
of this
already.
order.
So,
Ibid,
I really
same.
don't know.
On June 4th, 1999, the state trial
Alright, I
court
really feel like I have
modified the
enough
terms of
stuff
the
right now,
restraining order
and I would like
made
to
it
go to
permanent.
that.
The modified
Oh
order
my god,
gave
look at all of this
respondent's
coal.
husband the right to spend time with his 3 daughters,
Okay, that's the
ages
notable thing.
10, 9, and 7,
He had a right to spend
on
time with them.
alternate weekends for 2 weeks during the summer.
So
and,
he had
upon
visitation,
reasonable
essentially.
notice, for a midweek dinner visit
Upon reasonable
arranged by
notice,
the
midweek dinner
parties.
visit. But it
The
has to be
modified
arranged.
order also allowed him to visit. 545 US
Yeah, it's gonna do
2,
this again where it reads nothing.
Unit
But that
76
seems to be part of the facts of the case. The restraining order was there, which created a dynamic in which you have visitation then, essentially.
Open.
Oh, that's not great.
Cite as
Um,
545 US.
Man, more iron ore sounds
748,
great. Oh my god.
2000.
Oh my god.
Opinion of the court.
Oh, I just got cooked.
750.
All my stuff. Wait a minute. Has all the iron I've been mining not been doing anything?
Parenting time.
No. Where's all the iron I've mined?
ID at 1097.
Oh, I forgot what iron ore looks like in the new
majority
game. Holy crap, that
According
had
to
me
the
confused.
complaint, at about 5 or 5:30 p.m. on Tuesday day, June 22nd, 1999, respondent's husband took the 3 daughters while they were playing outside the
So
family
he just
home.
took the kids while they were outside in the
advance
neighborhood.
arrangements had
No
been
arrangements were
for
made,
him
so
to
he's
see
in
the
violation
daughters that
of
evening.
everything. He's fully in violation.
When respondent noticed the children were missing, she suspected her husband had taken them.
Okay. And then
At
did
about
what any
7:30
common sense person
p.m.,
would do if they
she
were
called the
a normal
Castle
raised
Rock
American,
Police
which is
Department,
calling her local
which
police department.
dispatched 2 officers. The complaint continues. When the officers
They sent 2 officers at
arrived,
7:30.
she showed them
the copy of it.
TRO and requested that it be enforced, and the 3
Then
children
nothing
be
happened. No
returned to
enforcement,
her
nothing.
immediately. The OFFI SARS stated that there was nothing they could do about the TRO and suggested
Like,
that respondent call the police
I need
department
to
again
increase
if
the
the
render
3
distance
children
again.
did not return home by
so just
10
fuck you.
p.m.
We're not getting him. Like, he's clearly in violation of the
126
order, and they're just like, fuck you, we're not doing anything.
At approximately 8:30 p.m.
Just reading the facts of this
respondent
case should
talked
make
to
your
her
blood boil.
husband on his
It should make you,
cellular telephone.
I think it would give a normal person,
He
like,
told her he
a
had the
visceral
3
internal
children
reaction of,
at
like,
an
my children are
amusement
missing,
park in Denver.
and you're doing nothing.
Ibid.
That amusement park is called Elish Gardens. I've been to
She
it.
called the police again and asked them to have someone check
Cool.
for
Couple of
her
dogs real quick.
husband or his vehicle at the amusement park and put out an all points bulletin for her husband, but the officer with whom she spoke refused to do so.
Yep.
Again telling her to
Yep. Look at this. Look at this. You're a mom. Your children are gone. Your husband has a history. So an important context is like, What if she's just evil and her husband's a good man? He has a history of being controlling and overbearing, and he has been a danger to himself in front of his children before. It's going to be dark, so it's a quick warning, but he tried to hang himself in their family garage, and his children walked in on him trying to end his life. Like, he just kind of suddenly got extremely mentally unstable. And had the capacity to be a threat to these kids. So the mother sought a divorce because, yeah, that's a crazy thing. That's a hard thing to pull out of for a relationship. So she's in the middle of filing for divorce. She's got a restraining order. He has a history of at least being a threat to himself. His behavior is erratic. He has some of the other common sense telltale signs of potentially exposing the children to harm and risk. You'll note that a lot of people like me who have struggled with their mental health kind of choose not to have children for a similar reason. So I can only stand by her reasoning that, like, hey, I'm going to keep calling because he took our kids without arranging. He's in violation of the court order. I want my kids back. I'm worried about them. Can you imagine your mom, your three daughters, by the way, all below the age of 10. They were outside a normal, safe neighborhood. Castle Rock is nowadays it's a small, rich white town in Colorado. That leans kind of conservative, and they're in the neighborhood, they're on their bikes, they're chilling, they're having fun, and then they're gone. And you know your husband has a history, you know, as a man in the fucking 90s, that like he's gonna be fucking serious about responding. This is not many years after a time period where like beating your wife was legal in the US. Like, this is not far off from that time period. Even if you think the 90s was just recently, it was not. That was like 30 years ago. So yeah, I don't know. I believe the murders that resulted from this happened in 1999, it's a year after I was born, and the case got ruled in 2005. So it took a long time for her to be heard by the Supreme Court, and then promptly told no, which is still an embarrassment upon our entire country, in my opinion. But look at this. You've got, these are facts of the case. This is not disputable. These calls happened. They were documented. We had systems for documenting them. She calls again and again and again and again over like 12 hours or 10 hours, and the police come and see her, and then they're like, well, we're not going to do anything. And then they're like, call us back later. Call us back. They didn't say it, but they're saying call us back when they're dead. Call us back when something happens. We're not here to protect you. We're not here to help you. Call us back when someone's dead. Call us back when someone's smoking weed. Call us back when you're afraid of a black dude in your neighborhood. Unfortunately, this isn't enough. Ironically, the woman, Jessica, is a woman of color. Her husband was as well. But yeah, it's just call us back when something happens. Let us know when someone dies. That's what police are for. We're not here to protect you. We're here to respond to crime, not do anything about it.
10 p.m. and see if her husband returned the girls.
These kids are gone. Fuck you mean wait? Fuck you mean wait? If she had like got a gun and found her husband and like successfully gotten a shootout with him and saved her children, she would have gone to jail.
10 p.m. Respondent called the police and said her children were still missing, but she was now told.
There's that lava pool over in that desert area, which I might need to take a look at again later.
She called at midnight and told the dispatcher her children were still
getting a bunch of food real quick.
She went to her husband's apartment.
Food is more important in this game than I remember.
Called the police at 12:10 a.m. She was told to wait for an officer to arrive. When none came, she went to the police station at. It is
there really needs to be a setting where you can't hit your dog with your sword.
To our decision, whether respondent showed the police only the original TRO or also the permanent, modified restraining order that had superseded it on June 4th. 5:45 U.S. 2.
They just failed in every way possible. They failed to respond. They failed to. Why are there so? What is going on with the sea? Why are there multiple villages? I haven't changed anything of the settings for this.
PGT open. 700.
It was normal. I started it on normal difficulty. Does that affect the rate of villages? It does, right? I didn't change it. I'm going insane.
Opinion of the court. 12:50
New World Survival Mode.
Submitted an incident report. The officer who took the report, made no reasonable effort to
I don't know.
enforce the TRO or locate the 3 children. Instead,
It's on easy.
he
Oh, I
went
can
to
look at
dinner.
with F3, can't I? Can't I see
ID
how if
at
it's hard or easy?
127A.
Local difficulty
At
1.50. What does that mean?
approximately 3:20 a.m., respondent's husband arrived at the
That's
police
normal, right?
station and opened fire with a semi-automatic handgun he
I don't
had
know.
purchased
I haven't.
earlier that
I have
evening.
not consciously changed anything.
Police shot back, killing him. Inside the cab of his pickup truck, they found the bodies
Oh.
of all
Oh,
3
oops. Sorry, I got
daughters,
scared. Something scared me
whom
on
he
my
had
own.
already murdered.
Fast, fancy clouds, vanilla.
Ibid.
Oh, I have it set to fast. Let's make it look pretty then.
On the basis of the foregoing factual allegations,
Fabulous. There we go.
respondent brought an action under
Wonderful.
Reverend Stat Section 1979.
Okay, I don't know. I haven't changed any settings. I think I'm just getting a very busted seat on my first try, which is kind of insane in my opinion. That is insane.
That the town violated
Whatever.
the due process clause.
Oh my god, I'm out
because
of room.
its police department had an official policy or custom of failing to respond properly to complaints of
I don't need
restraining
this armor
order
trim. I can't imagine that's
violations,
useful to me.
and tolerate d. the non-enforcement of restraining orders by its police officers.
Should I plant wheat or potatoes in this
To
run?
pet for cert 129.3.
Based on this, I
complaint
should probably plant
also
wheat because I'm already
alleged
getting a
that
bunch
the
of
town's actions
hay and bread out of
were
this.
taken either willfully, recklessly,
Again,
or
so
with
due
such
process,
gross
right? 14th
negligence
Amendment
as
says
to
everyone gets due
indicate
process under the
wanton
law,
disregard
and that the
deliberate
government cannot
indifference
interfere with a
to
person's life, liberty, and
respondent's civil
property.
rights. Ibid.
So this sounds like an issue of civil rights. You
Before
did not
answering the
protect this
complaint,
person.
the
You failed
defendants
her.
filed a motion to dismiss under Federal Rule of
Yay!
Civil Procedure
Well, I guess I
12,
should. You know what? I'm just gonna make this house my own bed.
6.
This is just my house now.
The district court granted
Forget
the
everyone
motion,
else. This is my house now.
concluding that, whether construed as making a substantive
Yeah, do
due
that. This is my house now.
process or procedural due process claim, respondent's complaint failed to state a claim upon which relief could be granted. Panel of the Court
What
of
we got?
Appeals
Oh my
affirmed
god!
the
What?
rejection
Okay,
of a
I'm really
substantive
genuinely
due
tripping. Am I in
process
like an
claim,
easier version of the
but
game right
found
now?
that respondent had alleged
I
a
didn't click, did I, when I
cognizable
started?
procedural
You know
due
what I can do? I can
process
probably go back on
claim.
my own video. I'm gonna do that.
307F, 3D,
God, I'm just doubting. I'm worried. What if I'm
1258,
accidentally playing on easy and then like the speedrun isn't as legit as I'd like it to be?
On rehearing and
Oh, I don't really need
a
this,
divided.
actually.
3 police officers
Who are-
were
what are you?
also named as
Mason.
defendants in the complaint, but the Court of Appeals concluded that they were entitled to qualified immunity.
Yeah, I hate hearing that. It only gets mentioned a couple of times in this whole document, but like at the core of this should have been the definition of qualified immunity. Think I'm gonna plant potatoes.
Respondent did
get rid of
not
this.
file a cross petition challenging that aspect of the judgment.
Wow, I have like the most
545
busted number of
US
shit this
2.
early in the game. It feels insane.
Unit 76 Uruguayan pesos. March
Uruguayan
26th,
pesos? What the
08,
fuck is it reading?
17 and 18
When it does that
seconds.
shit, I'm so
Pages
baffled every
PGT,
time.
Open.
Oh, was that just here? I
Cite
clearly
as
don't know how to look around.
545 US 748.
They got cats?
2005.
That's fun. I'm taking your hay.
Opinion of the court.
Hey, why the hell are my dogs eating
755.
those horses? I didn't say to do that.
Court reached the same disposition.
Why'd you do that?
Concluding that
Did I hit one?
respondent had a protected property interest in the enforcement of the terms of her restraining
So again, it's this
order,
reasoning that
and that the town had
a
deprived her of due process because
restraining order is actually
police
property
never
given to you by the
heard
government. So
nor
if they failed to do their
seriously
end, that
entertained her
means
request to enforce
they
and
violated
protect
her due
interests
process
in the
and
restraining
got in the
order.
way of her right to the property she was given, which is a document saying you're going to
366
restrain my husband
3D at 11:01,
and respond.
11:17. We
Oh my
granted
god,
certiorari.
I'm tripping. So when Minecraft speedrunners actually
543
get shit, like,
S
is this how it goes? They just get like all the food they want or something? Or is this,
2004.
like, what's going on?
2. The 14th Amendment to the United States Constitution provides that a state shall not
Constitution,
deprive any
they say.
person of life, liberty, or property
What is that
without
noise?
due
Why do my dogs
process
sound
of
like that?
law. Amped. 14.
So I really do need to
Section
check
1.
everything out. There could be
In 42
Yeah, this. There could be one of
SC,
these.
Section
Highly relevant.
1983, Congress
Needed
has
for later in
created
the
a
game for
federal
me.
cause of action for the deprivation of any rights,
Okay. Wow.
privileges,
What is this?
or
What is this?
immunity
Enchantment book.
secured by the Constitution and laws.
Okay, maybe I can put that on some. Oh, what do I need to
Respondent
enchant
claims
though?
the
I need an
benefit
enchanting
of
room.
this
I'm not doing that in
provision
this
on the
run.
ground
That's
that
just not
she had a
viable.
property interest in police enforcement of the restraining order against her husband, and that the
I think I
town
already took these
deprived
crops.
her of this property without due process by having a policy that tolerated non-enforcement of
Non-enforcement.
restraining orders.
This all seems so reasonable,
As the
and for
Court
the
of
fact the
Appeals
Supreme Court is saying no is so
recognized,
insane to
we left a
me.
similar case.
And just what are the cultural and societal
Tie-in
consequences
unanswered
of
in
ruling the way
Deshaney
that they did
v.
here?
Winnebago County Department of
This is the
Social
one I've read
Service,
before. Okay.
489.
This is an excuse to talk about what I have memorized. In Deshaney versus Winnebago County Department of Social Services, there was 2 enchantment tables, 2 brewing stands. I really don't need that. In this case, it was a father with a history of abuse to his, I believe, son, 4-year-old son. Father had a history of abuse. I don't really remember what the situation is with the mother or even why the father was in the kid's life if he was this fucking evil. But sure, leather cap, free. Yeah, I just need to do something with this leather cap. The father had a history of abuse. A bunch of people knew, and yet they still just kind of ignored what was going on. The Department of Children's Services or Social Services, whatever it's called, the Department of Social Services, CPS, essentially, just as the adults in the room, CPS completely and objectively failed everyone horribly. And you know, they did like a review of the father and his prior abuse of the child, and they ruled that like, oh, he's fine. It's fine. You know, let the kid be with his dad. Let the dad be with his kid. And then the father beat his 4-year-old son so bad that it caused some sort of brain injury, maybe a traumatic brain injury, maybe something else that was so profound that the child was left permanently unable to function cognitively in a normal way. Like the kid was in a coma or something and he got beat that bad by his dad. So that fucking happened. And the Supreme Court ruled that, because I believe it was the child's mother, that I need a bigger area to be in, and I also need that lava pool. So I might just have to move on from here and take what I've got. I think I'm going to do that. Do I have lamb chops? I don't think I'm going to use many emeralds in this run. Those are going to be useful. I don't need gold nuggets. Gold I will keep, though. Don't need a bundle. Okay, let's get this stuff out of here. In Deshaney versus Winnebago County Department of Social Services, I believe it was the mother who sued and was like, hey, the social service system here completely failed my son. That's why he's permanently has now a mental disability due to injury, an intellectual mental disability, because he was beaten so bad that it, like, I believe it did brain damage. And so her suit was like, well, the government robbed my child of the so-called life and liberty that you all talk about so much. And in fact, this social service system essentially enabled it. Even though they didn't commit it, they enabled it by being present and failing to do their like one job. And the Supreme Court ruled, nope, government systems have no obligation to do right by you. They only have an obligation to not do wrong by you. And they, the big kind of center of the Supreme Court ruling in this case was that the government is not there to protect you from other people, private citizens, private parties. The government is only there to protect you from itself. So, essentially, it's like saying the government can neglect its responsibilities to you, but it's always okay as long as it's the government doing the neglecting and not a private party. And also, we can't do anything about private parties because the Constitution only worries about us getting in your way, not other people. So that's kind of fucking insane. From like an anarchist perspective, it's all bunk. Like, we should just not do any of this. Fuck this, right? But from like just a normal human perspective, looking at society as it is and as it stands right now, it's almost worse that people are taught to trust these systems in these ways to this degree. And then they're not just abandoned by the systems, they're harmed by the existence of these systems and the false promises that they make. So a lot of this Supreme Court case really hedges on the a priority, or the court precedent decision that in DeShaney versus Winnebago County of Department of Social Services, the government has no obligation to protect you from other people, and the government only has an obligation to protect you from itself. That's insane. That's like, as I when I first read this document and some of these quotes, my main conclusion was that this is literally worse than what average people think anarchism is. When people think of like Mad Max chaos with no systems of justice and accountability, I'm going to be completely real. This is worse than chaos. The chaos that people say they are so against. This is actually worse than that chaos. At some point, dystopia and the failed state, the failure of your government, of your state, is actually more horrifying than the violence of like being randomly murdered by Grug. Like it's some primitivist conception of anarchy, which again, that's not what anarchism is. It's actually way fucking better. But yeah, I don't know. It's all just fucking insane. That it's worse than worse than primitivism. The idea that like so-called like defenders of the West are all in their feelings about how like the U.S. should be a utopia. You know, it's great. The West is incredible. It's truly a transcendental culture, and it needs to be protected, and we need to save, the fall of the West. You're not saving the fall of anything. It's been fallen the whole time. Like what it stood for and what it was terrible. It is terrible. And this is all unethical. At some point, a failed state is actually worse than just anarchism. And I don't even mean good anarchism. I mean lazy, primitivist, shitty pop culture comprehension of what anarchism is. At some point, a failed state is worse than that. And I feel like this Supreme Court case is that. Okay, I'm tripping. What the fuck why are there so many villages suddenly? I'm going back in my stream and I'm checking if I accidentally set it to easy or something, because I don't like this. This feels like cheating. I can even tell something feels off balance. Okay, let's see. So I'm going through the stream right now and relooking. New world, game difficulty normal. Is this just the luck of the seed? Game mode survival, difficulty normal. Let me see me click it. I'm clicking it. It's on normal. Is this just like the best world ever? Am I just cheating? Like, what is going on? Why is this run so easy? Why is there a million freaking why are there so many villages? Oh, there's that. And then there's a village over here, right? What is going on? Okay, but I was thinking of making this desert temple my house, because the desert's going to be a great place to look for what's it called? I can't remember suddenly. Oh. Do I want to use this as my like home base, or do I want to use something lower? Kind of like this, but it's all made of sand. Doesn't that mean it's going to fall apart at some point? Shouldn't I build like a normal cobblestone house then? Maybe I can just build my cobblestone house in the middle of the desert. But then I won't have any dirt blocks for later. But I need this. This is what I need. I need to build a portal here using this lava portal. Lava pool. Oh, I remember. I was going to the village because I forgot to go get a bed. Because I'm an idiot. Oh no. Spider's coming after me. Oh crap, it got me. Okay, I'm going to go to this village. And I'm going to grab a bed, and I'm going to build my home somewhere out here in the middle of nowhere. I guess I'm going to raid this village too, and I'll build a home outside of it. No, but I want that lava pool. That's my issue. I remember. Back to reading.
For 89 U.S. 189, 1989.
This feels so
Another
broken. Is
case
this why
with
like the
Hyundai Neoblide
I don't know how fast the
tragic
world record speedrun for
facts.
Minecraft is, but it's
Local
like
child protection officials
like 5
had
minutes or
failed
something,
to
right? It's like
protect a
less than 10
young
minutes.
boy from beatings by his father
Yes,
that
this
left him
is good
severely
summary of the
brain
thing.
damaged.
Brain damage. There we go. That's what happened to him.
ID at 191 to
What
193.
is this? It's built into like a
We held
half
that the
open
so-called
mountain.
substantive component of the due process clause does not require
The state to protect.
state
Yeah,
to
isn't that
protect
insane
the
that they can
life,
just like say that in a
liberty,
quote?
and property of its citizens
The
against
substantive
invasion
clause,
by private actors.
I've lost it. Component of the due process
ID
clause does not
at
require the state to protect the life,
195.
liberty, and property of its citizens
We
against
noted,
invasion by
however,
private actors.
that the petitioner had not properly preserved the argument that, and we thus decline D to consider
This is so
whether
busted. This feels
state
like insane that there
child
are so many of these
protection
places.
statutes gave
I'm gonna go to
him
sleep and come
an
back.
entitlement to receive protective
What?
services in accordance with the terms of the statute.
Can these have crafting
an
tables in them?
entitlement which would enjoy due process protection. ID at 100.
Villagers can't make crafting tables, can they?
N2 545 US 2 Unit.
What was that?
76 Uruguayan
I'm gonna Google
pesos.
that. What is up with the
March
Dune thing I got
26th,
earlier?
08, 21, 17 and 18 seconds. Pages PGT. Open. 756. Castle Rock v. Gonzales. Opinion of the court. The procedural component of the due
This is
process
insane. I'm gonna like
clause
have
does
all the
not
food I
protect
need.
everything that might be described as a bene effort to have a property interest in a benefit.
Right, so we don't have a
person clearly
right
must have more than
to
an
police
abstract
officers doing their
need or
job. It's just
desire,
a
and more than unilateral
a
expectation of it.
discretionary benefit we are
He
given
must, instead,
by our
have a
ever so
legitimate
humble
claim
government.
of
Can you
entitlement
imagine how
to
the
it.
founding fathers would feel if they
Board
read
of
that like
Regents of State Colleges versus
the
Roth,
police doing the thing we pay taxes for them to do is just a nice little perk that no one actually has a right to.
577,
I couldn't imagine that. That sounds
1972.
so fucking. Look, these all have crafting
Such
tables. What is going
entitlements
on?
are, of course, not created by the Constitution.
I wonder what's up here.
Rather, they are created and their
Blast furnace.
science are defined by existing
Why are these
rules or
pigs?
understandings that stem from an independent
How much does this game
source such
change?
as state law. Paul versus Davis, 424
how do I go up this?
U.
I want to go up it.
690.
Okay, I'm gonna take a bed. I'm gonna go back to the desert. I'm gonna use that lava pool
1976,
to build a
quoting Roth, Supra
gate to the
at
nether.
577.
Nether portal.
See also Phillips versus Washington Legal Foundation, 524
Taking this?
U.S.
How do I grab it? There we go. Wonderful. All right, let's go back to there and see if I can remember where this desert temple is now. And then deserts are the best place to find lots of Endermen quickly, right?
If government officials may grant or deny it in their
Again, so
discretion.
the government is discretionary in their
CEG,
obligation
Kentucky
to protect us,
Department
the
of
thing we pay them to
Corrections
do.
versus Thompson, 490
I should have read that
U.S.,
case.
454,
Kentucky Department of Corrections versus Thompson.
462 to 463, 1989. The Court of Appeals in this case determined that Colorado law created an entitlement to enforcement of the restraining order because the court-issued restraining order specifically
It's just insane to
dictated
think that
its
like
terms must be
any
enforced,
conception a
and that
normal person has
state
ever had of
statute
like law
command
and what makes something
A,
legal
enforcement of the
is
order
like
when
just
certain
totally
objective
wrong.
conditions
Like it
were
doesn't mean
met.
anything.
Probable cause to believe that the order had been violated and that the
Move, dog.
object of the order had received notice of its existence. 366 F 3D at 1101 N5.
I think the last house I made was too small.
ID
I did not mean to
at
hit the dog that time.
1100 N4 ID at 1104 to 1105 NN9. Respondent contends that we are obliged to give deference to the 10th Circuit's analysis of Colorado law on
So essentially
whether
it sounds
she had
like
an entitlement
this
to
10th
enforcement
Circuit
of the
federal
restraining
court
order.
already ruled that
TR
like
of oral
they have a
R
job
52.
to enforce
will
the
not,
damn
of
restraining
course,
order.
defer to the 10th Circuit on the ultimate issue, whether what Colorado law has given respondent constitutes a property interest for purposes of the 14th Amendment. That determination, despite its 545 U.S. 2 Unit 76 Uruguayan pesos.
Why did my dog be barking
March
like that?
26th 08 21:17 and 18 seconds. Pages PGT open.
Whoa.
Cite as 545
Uh-oh.
U.S. 748.
Why do my dogs sound like that? Why do they
2005.
sound like robots when they bark? They make such a
Opinion
funny
of the
noise.
Court. 757.
Why do they sound like that?
State law underpinnings is ultimately one of federal constitutional law.
Oh my god, I had to get through so much
Although
sandstone
the
just to get to a little bit
underlying
of cobblestone down
substantive
there.
interest is created by an independent source such as state law. Federal
Oh my god, I couldn't
constitutional
even
law
get...
determines whether that interest rises to the level of
My
a
house isn't built
legitimate
yet though,
claim
I
of
need to do
entitlement
something.
protected by the Due Process
Okay,
Clause.
let's just do this and hope my stuff doesn't get ruined.
Memphis Light, Gas and
How do you
Water
fuck that up?
IV Craft, 436.
Okay, so I feel like I've read
S
pretty much most of the
9,
majority opinion, and I think
1978,
what the document I read
quoting
last time
Rob
was missing was definitely the
Super
dissenting
at
opinion.
577,
Maybe even the concurrence too, because it was only 20
emphasis
pages,
added,
but this is much longer.
CF United States X Rel. TVAV Paulson, 319.
Respawn point reset.
S
Dog be gone.
266.
I'm gonna grab one of
279.
these. I'm gonna
1943.
make a crafting table real quick.
Resolution of the federal issue begins, however, with a determination of what it is that state law provides. In the context of the present case,
I think
the
I should make a
central state
bunch
law
of torches
question
before
is
night
whether
comes
Colorado
and protect
law
my
gave
entire area.
respondent a right to police enforcement of the restraining order. It is on this point that respondents' call for deference to the 10th Circuit is relevant.
Why do my
We
dogs
have
keep
said
barking
that
like
a
that?
presumption of deference
Are they not
is,
dogs? Are they
given the
coyotes?
views of a federal court as to the law
Did
of
I
a
just
state within
befriend a
its
coyote instead of a
jurisdiction.
dog?
Phillips, Supra, at 167. That
You know what though?
pre-sump
I'm like
time can be
hyping up like how
overcome,
good this
however.
Minecraft world is, but I'm
See
sure
Levitt
that
versus
speedrunners
Jane
in
L.
their
518
endeavors to generate a
U.S.
100,000 different worlds
137,
have found a world that's like
145,
got a
1996,
got a
per
freaking,
curiam,
you know,
and
you
we
spawn
think
in a
deference
village with a pool
inappropriate.
and diamond gear and some shit
The
like that.
10th Circuit's
This just feels
opinion,
really good to me.
which
Like
reversed the
a
Colorado
little undeservedly
District
good.
Judge, did not draw upon a deep well of state-specific expertise, but consisted primarily of quoting language from the restraining order, the statutory text, and a state legislative hearing transcript. See 366F, 3D, at 1103 to 1109. These texts, moreover, say nothing
Dog,
distinctive
do
to
not teleport into my
Colorado,
face like that.
but use mandatory language that, as we shall discuss,
Alright,
appears
instantly
in
into
many
coal.
state
I
and
did not need
federal
coal right now.
statutes.
I'm not going to get any coal from this, I'm pretty
As
sure.
for case law, the only state law cases about restraining orders that the
Oh, I am
Court
getting
of
coal.
Appeals
Huh.
relied upon were decisions of federal district courts in Ohio and Pennsylvania and state courts in New Jersey, Oregon, and Tennessee. ID at 1104 to 1105, N9, 1109.4. Moreover, if we were simply to AC. Most of the Colorado law cases cited by the Court of Appeals appeared in
I don't know how
footnotes
much cobblestone
declaring
I'm gonna
them
need,
to
but it's gonna be a lot.
irrelevant because they involved only substantive due process. 366F, 3D, at
I
1100
don't know. I
to
kind of like a stack of
1101
cobblestone before I get
NM.
going too far.
4 to 5, only statutes. 545 U.S. 2.
It's a good progress though. I'll have another portal done
Unit
very soon.
76 Uruguayan
And a house
pesos.
built? kind of ready to enchant stuff too.
21:17 and 18
I
seconds.
really do not care for this copper at
Pages
all.
PGT. Open.
Yeah, that I believe. This is... I cannot get through this.
758. Castle Rock v. Gonzales. Opinion of the court. Except the Court of Appeals
Do I have my brightness set to max?
conclusion,
I should.
we would necessarily have to
Yes, I do.
decide conclusively a federal constitutional question.
37 should be enough. I should
whether
really
such an entitlement constituted
go build the house now. But the
property
issue
under
is...
the
Oh, it's
Due
still daytime.
Process Clause, and, if so, whether petitioners'
Wow,
customs
okay.
or
I already went way
policies
too far with this one.
provided too little process to protect it. We proceed,
Dogs.
then, to our own
What are you doing, dogs?
analysis of whether
Why are you on the
Colorado
way like this?
law gave respondent a right to enforcement of the restrain ing order. Point 5. B. The critical language in the restraining order came not from any part of the order itself, which was signed by the state court trial judge and directed to the restrained party, respondent's husband, but from the pre-printed notice to law enforcement personnel that appeared on the back of the order. See Supra, at 751
No, I ran out. You're
to
kidding me.
752.
How much crap do I need? The sun's going
That
down.
notice effectively restated the statutory provision describing
I know
peace
that I don't
officers'
have
due
to
ties
use cobblestone for
related
this,
to the
but I just
crime of
prefer to.
violation of a restraining order. At the time of the conduct at issue
Ah.
in this case, that provision
Oh, this is almost
read
broken
as
anyway.
follows.
That would be dumb to go down. I need to make one.
A.
Oh, and I
Whenever
used
a
all of it again
restraining
because I'm
order is
stupid.
issued, the protected person
Give me down
shall
there.
be
I need to
provided
make a
with
frickin'
copy of such.
stone axe.
Without
come on.
restraining orders, ID
Yes.
at
Wonderful.
1101 N5 or Colorado's
making a stone axe this
Government
time.
Immunity Act, which the Court of Appeals concluded applies
State tort.
only to
Apparently a tort is
state
like
tort law
a wrong,
claims,
just a
ID
personal
at
wrong.
1108
When someone personally
to
wrongs you, I guess.
1109 N12.
Okay, what am I doing now?
Our
I'm building
analysis
a...
is likewise unaffected by the Immunity Act or by the way that Colorado has dealt with
Okay, I need way
substantive
more.
due process or
You need a lot of
cases that do not
cobblestone.
involve
Like,
restraining
very early.
orders. In something of an anyone but us approach, the dissent simultaneously,
Okay, I've read
and
this.
thus unpersuasively,
So now
contends
I get
not
to
only
hear
that this court should certify
the
a
dissent and
question to
the
Colorado Supreme
majority
Court
kind of fighting
post
each other.
at 776 to 778, opinion of Stevens, J., but also that it should defer to the 10th Circuit, which itself did not certify any such question, post at 775
I wonder how pissed John Paul Stevens would be about what Trump has done. He was a Republican,
in this case
and he consistently rules right in the Supreme Court. He rules in a way I consider very moral.
CTR of oral R
He always
56,
dissents when shit is bad. He made
Petitioner's
incredible
Counsel
predictions in
ING
Citizens United versus
certification
FEC.
ID at 25 to 26.
I'm sure he has some evil ass
Counsel for
rulings
the
too,
United
and
States
it's
arguing
wrong
against
to
certification.
just always say all
oral
Supreme Court
argument,
judges are evil for one ruling, but like they have giant responsibility, great power, great responsibility, right? They have some of the greatest power in the country,
ID
in the
at
world, really.
53. 545
I don't know.
US 2.
People are more complicated than black and white.
Unit
I just mean to
76
communicate that I am very
Uruguayan
frustrated
pesos,
with the decision in this
March
case.
26th,
It's fucked up.
21:17 and 18
And,
seconds. Pages
I think not
PGT,
flexing
open.
your obsession with always being
Cited
perfectly aligned to the law
545
and just failing to
US
interpret the Constitution in a way that is human and moral,
2005.
I just find that
Opinion
kind of
the
unforgivable. It's just very messed up.
court,
general.
759.
All right, I got more cobblestone. It's
Order.
nighttime. I should really
A peace
sleep.
officer shall use every reasonable means to enforce a restraining order. B. A peace officer shall arrest, or, if an arrest would be impractical under the circumstances, seek a warrant for the arrest.
Yeah, I'm not
of a
even reading it,
restrained
and I knew that
person
was about to
when the
happen.
Peace officer has information
It is
amounting to
nice, kind of already
probable
having
cause
read
that
these documents. I can kind of tell what's coming.
I. The restrained person has violated or attempted to violate any provision of a restraining order, and
Good.
2.
What am I
The
building
restrained
next?
person has been
Chess, I
properly
guess.
served with a
Right?
copy of the restraining order, or the restrained person has received actual notice
I
of
really
the
don't think that's a great use
existence
of
and
my
substance
chess.
of
I should
such
just
order.
put stuff away.
C.
What I need
In
now is
making
to
the
build
probable
20
cause
stoves,
determination described in
20
paragraph
ovens,
B
many as I can make.
of this subsection. 3. A peace officer shall
I imagine
assume
3
that
should be
the
plenty, right?
information received
That's what I
from the
made last
registry
time.
is accurate. A peace officer shall enforce a
Where do I
valid
build it?
restraining order
Can I build them all
whether or
vertical?
not
Hell
there
yeah,
is
I'll
a
do that.
record of the restraining order in the registry. Colorado Reverend Stat Section 18.
If you failed to put the restraining order in your registry, that's your fuck
680.3.5.
up. You should listen to the damn
Lexus
woman who's freaking out because her husband kidnapped her kids.
Added. The Court
God,
of
it's just such a
Appeals
non.
concluded that this
It's just not an
statutory
excuse
provision,
to just dismiss her
especially
again and
taken
again
in
and again.
conjunction with a
Oh, just
statement
wait,
from its
just wait a few more
legislative
hours when they
history,
show up dead.
6, and with another statute restricting.
Jesus
The Court
Christ.
of Appeals quoted one lawmaker's description of how the bill would really attack the domestic violence problems.
Yeah.
The entire criminal justice system must act in a
Wow, this will be
consistent
enough
manner,
food for the rest of the
which
game.
does
Won't
not
it?
now occur. The police must make probable cause arrests.
You would assume that the police must make probable cause arrests, but
Judges
I don't
must
know.
apply appropriate
They seem kind of against it.
sentences, and probation
Okay, let's start
officers
organizing all
must
of my food for the
monitor
rest of the
their
run
probationers
here.
closely.
Dude,
And the
enchanted
offender
golden
needs
apple
to
is
be sentenced to
insane.
offender-specific therapy. The entire system
This
must
is
send the
food.
same message.
Sharpness, bane of
Violence is
arthropods.
criminal.
Man, I think I
And
just
so
need
we
a
hope that
an
House
anvil
Bill
to do that, but
1253 starts
I'm
us
not sure it's
down
going to be
this
worth it.
road.
Okay, we need to get this iron
366F
cooking pretty soon.
3D at 1107.
Potatoes, huh? I
TR
think I might
of
make a potato
Colorado House
farm.
Judiciary hearings on House Bill
Just so I don't,
1253, February 15th,
I might get screwed and start losing a lot of food.
1994. Emphasis
This stuff,
deleted.
all this stuff has to cook anyway, so.
545 US 2.
Right. I have a bunch of leather.
76
I'm already wearing a leather
Uruguayan
cap,
pesos,
so
March 26th,
don't know why it's where it's reading those
21,
letters every time it
17
says
and
that, but
18
whatever.
seconds. Pages PGT. Open.
Hey, it's some armor. I'll take it.
760.
Alright, I'm gonna want a sword
Castle Rock v.
and a
Gonzales.
pickaxe. The potato situation I
Opinion
will
of
deal
the
with later.
Criminal
I
and
really
civil
should
liability for officers
build
making
a-
arrests. 7. He established the
No, I should build a lot
Colorado
of stuff, apparently.
legislature's clear intent to alter the fact that the police were not
Okay,
enforcing
iron next.
domestic
Let's get
abuse
that done.
restraining orders, and thus its intent that the recipient of a domestic abuse restraining order have an entitlement to its enforcement. 366
That should be enough to go
3D
get some dirt.
at
But where can I even
1108.
get dirt in the game right now? Like,
Any other
there's no
result,
fucking
it
dirt
said,
nearby.
would render domestic abuse
It's just a
restraining
giant
orders
desert.
utterly valueless.
Uh-oh.
ID at 1109.
Oh, leave me alone.
This last statement is sheer hyperbole. Whether or not respondent had a right to
Fuck you mean
enforce
it was
the
sheer
restraining
hyperbole?
order,
Look at
it
what's
rendered
happened
certain
to
otherwise lawful conduct by her husband
policing
both
since then.
criminal and in contempt
Is
of
that
court.
dirt?
See sections 18,
Oh, I can find dirt underwater.
3.5, 2A.
There we go. Okay, I'll get some dirt going.
The creation
think I'll
of
make a really
grounds on
tiny
which he could
farm
be
instead of a big
arrested,
one. Like last time, I had a
criminally
big one for no reason.
prosecuted, and held in contempt was hardly valueless,
I just
even
need,
if the
I believe, 30
prospect of those
blocks
sanctions
to make
ultimately failed
a
to
one
prevent him
large
from
farm.
committing 3 murders and a suicide. We do not believe that these provisions of Colorado law truly made enforcement of restraining orders mandatory. A
more dirt.
well-established
We're good.
tradition
We're
of
good.
police discretion has long coexisted
Still
with
hate reading
apparently
that.
mandatory arrest statutes.
Policing is discretionary.
In
They
each
don't
and
actually have
every
to protect
state, there are
people.
long-standing
Like, for one,
statutes that, by
they're
their
barely even
terms,
addressing the fact
seem to
that
preclude
a normal average
non-enforcement
American is going
by
to
the
assume that police have an
police.
obligation to protect them.
However,
Duh.
for a number of
What do I pay
reasons,
taxes for?
including the legislative history,
What is the social contract?
insufficient resources,
One, they're
and
kind
sheer
of
physical
skirting around that and
impossibility,
trying to
it
almost
has been
say, like,
recognized that
nah,
such statutes
no one's
cannot be
obligated to
interpreted
protection
literally.
by the police they pay for.
They clearly do
Are you
not
kidding me?
mean that a police officer may
What?
not lawfully
Such entitled
decline to
Americans,
make an
thinking
arrest.
we deserve representation
As to third
because of our
parties in these
taxation.
states, the
Ridiculous
full
Americans. How
enforcement
dare you think that?
statutes simply
Just saying, I
have
think
no
the founding
effect,
fathers would fight these
and their
guys.
significance is,
I think a founding father would
under
be like, yeah, I get it.
Colorado
I get what you're
Reference
saying
Section 18, 6,
in not wanting the government to have too heavy a hand, or for people to be too dependent on the government. I get that, actually. I get it. Like, no, she should just have a gun. But, you know, duels used to be legal. People used to be able to defend themselves and their persons in a very different way.
And with malice, or violated rules adopted by the Colorado Supreme Court. 545 U.S. 2.
Okay, I figured out how to do this last. We're going to see if I can figure out how to do it again. But I am still going to build this farm real quick. Just in case. You never know. I might need food.
18 seconds. Pages PGT. Open.
I think that's
Site
15.
as 545 U.S. 748 2005. Opinion of the court.
Okay, and I've got plenty of water and plenty of magma right nearby.
Further diminished. 1 ABA Standards for Criminal Justice 1 to 4.5. Commentary. Pages 1 to 124
Was that middle?
to 1 to
Did I guess it?
125.
I was wrong.
2D edition
Is that middle?
1980. Footnotes
there we go.
omitted. The deep-rooted nature of law enforcement discretion, even in the presence of seemingly mandatory legislative commands. Chicago versus Morales.
I clearly need to read Chicago versus Morales at some point.
U.S. 41, 1999, which involved an ordinance.
Oh, I do remember the summary of this, though.
Shall order persons to disperse in certain circumstances.
It's like, police have to order people to disperse, but they're actually not required to order them to. It's like, again, why use that language? The shall bullshit.
The mandatory language of the ordinance, A.F. Ford, ed., the police no discretion. ID, at 62, N. 32. It is, the court proclaims.
Why do these dogs bark so much? Oh, you know what? It's probably because they want food. Eat.
That all police officers must
you're already
use
healthy.
some discretion in
Eat.
deciding
Okay,
when
well, I guess
and
we're
where
gonna
to
get more dogs now.
enforce city ordinances.
Great, that's funny.
Ibid, emphasis added. Against that backdrop,
this is the most
true
busted
mandate of
run.
Police action would require some
Oh
stronger
my god.
indication from the
Then what?
Colorado
Is there going to be a state
legislature
one day
than
that's like, yeah,
shall
cops have
use
to do their
every
job and becomes a
reasonable
fucking
means to
utopia?
enforce a restraining order, or even
Fucking
shall
insane,
arrest
all of this.
or seek a warrant. Sections 18, 6, 803.5, 3a, b. That language is not perceptibly more mandatory than the Colorado statute, which has long told municipal chiefs of police that they shall pursue and arrest any person fleeing from justice in any part of the state, and that they shall apprehend any person in the act of committing any offense.
Shall. So, like, I mentioned this in the last time, the first round of reading this document, but it's the Spider-Man problem. You have power, which means you should be responsible, but you're going to stand by while something bad is happening, and now your Uncle Ben's dead. Well, now people are dead because the cops stood by and didn't do it. They had power in a position of authority and an expectation of a duty of care, and they failed. Now Uncle Ben's dead. Now this woman's family is dead. How do you fuck that up? Spider-Man fucked it up one time, learned his lesson. But these fuckers, cops get to fuck it up again and again and again and again. And it's okay.
Decisively against
Fuck that.
enforcement in
Fuck
a
that.
particular
The world can be
instance,
better.
point 8.
Things do not have to be bad.
Respondent in fact concedes
Basic
that
change
an
can be
officer
made
may
to improve the
properly
world.
decide not to enforce a restraining order when the officer deems a technical violation too immaterial to justify arrest. Respondent explains this as a determination
I
that
I
there is no
understand and do
probable
comprehend.
cause.
Where are my potatoes?
Brief for respond.
Oh, there they are. I
545
understand the
US
worry
2.
of like cops always arresting people every time they see them
Unit
doing something bad.
76
Then write the
Uruguayan
laws so they're
pesos,
light
March
enough that the little
26th,
things
08,
don't matter.
21:17
There you go. You get
18
both.
seconds.
You get your libertarian
Pages
minimizing big
PGT,
government thing,
open.
and you make the police actually do their job. It's not impossible.
762.
A better world is not
Castle
impossible.
Rock
You
v.
can do common sense things to make
Gonzales.
this happen. Other countries have probably figured this out.
Opinion of the court. The practical necessity for discretion is particularly apparent.
All right,
in a
now I would
case
like to take an
such as
attempt at
this
making
one,
the nether
where
portal.
the suspected violator is not actually present and his whereabouts are unknown.
But the concern is
CF
that I don't
Donaldson
think I'm very
versus
good at making
Seattle,
it. So
65 Washington Ave.
I have made it once though successfully.
661.
So there is that.
671 to 672.
Okay, I've got lava.
831 P. 2D
And I'm just gonna build it here, but I'm gonna need the dogs to go away for their own safety.
There is a vast difference between a mandatory
So
duty to
it's
arrest
this,
a
then that.
violator who is
Okay.
on the
Oh,
scene,
that
and
issue.
a
That happened
mandatory
last
duty
time.
to
I remember
conduct
it.
a follow-up investigation.
Okay,
To
so we're just gonna
locate
not
an
make that
absent
mistake. Okay,
violator.
dogs, come over here. I'm
A
gonna set you up
mandatory
over here.
duty
Come
to
on,
Invis
both of you.
Tigate
Stop
would be
teleporting.
completely open-ended as to priority,
Issue. Can I even
duration,
make a
and
puppy sit,
intensity.
or do puppies just free roam?
The dissent correctly points
No, I
out
can make puppies
that
sit. Good. Okay.
in the specific
Okay. Yep, I did this last
context of
time. I just
domestic
need to not fuck that up
violence,
again.
mandatory arrest statutes have been found in some states to be more mandatory than traditional mandatory arrest statutes.
Oh, it happened again.
Post at
Oh my god, I might lose all my lava because I
779
keep fucking this up.
784. Opin Ion of Stevens, J.
Okay. Okay.
The
No more fucking
Colorado
up, I guess.
statute mandating arrest for a domestic violence offense is different from but related to the one at issue
So
here, and it
2,
includes similar,
and then like a
though
few
not
high, right?
identical phrasing. See Colorado Reverend Stat Section 18,
Can I just-
6803.
Can I just do it like this? Can I just set this here?
1. Lexus
Can I do that?
1999.
I can. Nice.
When a peace officer determines that there is probable cause to believe that a crime or offense involving domestic violence
Pretty sure 2 is
has
good. It
been
just has to be
committed,
like several
the
high.
officer shall, without undue delay, arrest the person suspected of its commission. Even in the domestic violence
I
context,
think
however,
that is how
it
I
is
need to build it.
unclear how the mandatory arrest paradigm applies to cases in
I
which
think.
the offender is not
No,
present to be
I'm tripping,
arrested.
aren't I? Yeah, this is how it needs
As
to
the
go.
dissent explains,
Need to build up
post
as I do it.
at 780 to 781 and N8. Much of the impetus for mandatory arrest statutes and
Policy?
policies derived from the idea that it is better for police officers to arrest the aggressor in a domestic violence incident than to attempt to mediate the dispute or merely to ask the offender to
Oh,
leave
I
the
do not
scene.
know if I was ready to do several
Those
hours
other
of streaming
options
today.
are only
but-
available, of course, when the
Hey,
offender
I
is
think I'll
present
survive.
at the
Okay.
end. 28.
Okay.
We think, however, that a determination of no probable cause to believe a violation has occurred
Crazy
is
how people
quite
do this
different from
manually
a
by, like, just
determination that the
building like they're
violation is
crazy.
too insignificant
Okay, I think it needs to go 1 or
pursue.
2 higher.
545 US 2. Unit.
I think we're getting to the right length, the right height right now.
March 26.
Still wanna know why it says that every time.
17 and 18 seconds.
And then I don't need to finish
Pages
the corner, I think.
PGT, Open.
Nope, stop.
545.
Uh-oh, probably
US,
just ruined the rest of it, but conveniently I think I have it built, so.
2005.
A flint
Opinion
and
of the
steel,
court,
huh?
763.
Where am I gonna get a bunch of gravel?
Scene.
Real quick.
See
I still got
have
some of this left, that's
no
good.
right to choose. Mandated victim
Should be gravel somewhere.
participation in domestic violence prosecutions.
I
109
actually
R.
I really don't know where gravel is right now.
L. Rev.
That's not good.
1849, 1860.
Man, it really one thing can like just take a
1996.
run and just
The
slow it the
clear
fuck down.
trend
This is
in
gonna be it
police
for me, I think. I'm
practice
not gonna
is to
have
arrest
flint.
the batterer at the scene. Emphasis added. As one of the cases cited by the dissent, post, at 783,
That's plenty of bread.
recognized, there will be situations when no
Alright, I need
arrest
to
is
somehow
possible,
find
such as
flint.
when the alleged
So
abuser
I
is
need
not
gravel.
in the home. Donaldson,
Cool.
65
It's got to be
Washington Ave,
somewhere around the water.
at
You find gravel all the time in the water.
674,
You're so used to this is all clay.
831p, 2D,
Looks
at
that's andesite or
1105,
something.
emphasis added.
Gravel.
That case held that Washington's mandatory arrest statute required an arrest only in
Nope.
cases where the offender is on the scene, and that it did not create an ongoing mandatory duty to
Wow, this is gonna
conduct
take
an
forever. I'm
investigation
cooked. I should
to
have brought a
locate the
shovel.
offender. ID at 675, 831p.
Wow, I got a flint on the
2D
second
at
try.
1105.
The RNG feels
Colorado's
different
restraining
compared
order
to the last run.
statute appears
I don't know
to
what's going on, but
contemplate a similar
maybe I'm
distinction,
just getting better at
profit
speedrunning
ing
traditionally
when
because I've
arrest
just
is
watched it a bunch of times.
impractical, which was likely the case when the whereabouts of respondent's husband were unknown. The officer's statutory duty is to seek a warrant
Instead of
rather
making the
than
direct arrest. But
Section
like,
18,
I
6803.5.
you just failed as a community that exists to help people.
Respondent
Oh, we
does
did it.
not
Cool.
specify the precise
All right, I'm gonna
means
go
of
and immediately die and lose all
enforcement
my
that the
levels. That's the
Colorado
plan.
restraining order statute assertedly mandated.
I can
Whether her
spare a
interest
shovel.
lay in having
In fact, I'll make
police
several
arrest
ahead
her
of time
husband,
now.
having them seek a warrant
You know what?
for
I'm gonna
his
do that. I'm gonna
arrest,
prepare this
or
time.
having
Last
them
time I didn't
use
prepare for
every
shit.
reasonable means, up to and include ing arrest, to enforce the order's terms.
I'm just gonna
Brief
make
for
a bunch of
respond and
gear
29 to 30.9.
ahead of
Such
time.
indeterminacy is not the hallmark
Except
of
I
a
don't have
duty
enough
that is
cobblestone to even make
mandatory.
much gear. Great.
Nor can someone be safely deemed entitled to something when the identity of the alleged entitlement is
Sure,
vague.
dirt will be useful later.
See Roth, 408 U.S. at 577.
I need to really be sparing
Consider.
with my items as I do this.
Respondent
And then yeah, like
characterizes her
literally just a few
entitlement in
bread because I'm
various
going to die while
ways.
I'm there.
See brief for Respondent 12, entitlement to receive protective services, ID, at 13, interest in police enforcement action, ID, at 14,
Oh no, okay.
specific government benefit.
Well, that's gonna suck in its own
consisting
right.
of the government service of enforcing the objective terms of the court order protecting her and her children against
You know
her
what? This time it's
abusive
definitely gonna be
ID, at
the fortress. I'm not
32,
gonna be able to find it
T.
quickly.
He restraining
Oh, and
order
my
here
thing is already
mandated
broken.
the
That took
arrest
no
of
time
Mr.
at all to be
Gonzales
screwed.
under specified circumstances, or at a minimum required the use of reasonable means to
All right. Hey, we're out of
enforce
there.
the order.
Wow, we are in the middle of nowhere. I don't know how this is gonna go. Well,
Unit 76.
yeah, without
Uruguayan
a
pesos,
pickaxe, this is
March
not gonna go at all. In
26th,
fact, it's gonna be
08,
really awful. So I'm gonna go get
21:17
another
and 18
pickaxe and try to remember that pickaxes
Pages
break really quickly in this world.
Open. 700.
Okay, I need a fuck ton of cobblestone. I really need to stop being so slow with it.
Rock v. Gonzales.
Let's make a normal pickaxe finally.
Opinion of the court.
Classic iron.
Whether certain benefits were
Okay, but when we're in the nether, we're just gonna eat
by
through
rule
cobblestone,
or
so I'm gonna mine a bunch of cobblestone.
CF Natale versus Ridgefield, 170 F, 3D 258, 263, CA 2 1999. There is no reason to restrict the uncertainty that will preclude existence of a federally protected property interest to the uncertainty that inheres in the exercise of discretion. The dissent, after suggesting various formulations of the entitlement in question, and ultimately contends that the obligations under the statute were quite
Here's the thing,
precise.
though. We're still in the main part of the... Yeah, we're only on 17, so this is still them just responding to the dissent who's going to come after.
545 US 2.
It's kind of hard to read it kind of out of order,
Unit
almost necessarily.
76 Uruguayan pesos, March 26, 08, 21:17 and 18 seconds. pages PGT, open. 764. Castle Rock v. Gonzales.
Okay. That's, yeah, pretty much a stack.
Opinion
That's
of
good
the
enough.
court. Whether certain benefits were secure, d. by rule or understandings, cf. Natale versus Ridgefield.
I gotta read that too. There's just too many of these cases to read.
3D
Too many.
258.
Put this back.
263.
Keep some of this
CA
basic gear. I'm gonna take more stuff with me. I guess I'm gonna really try not to die
to
instantly.
restrict the
I guess I'll lose all this
uncertainty
gear.
that will preclude existence of a
And I
federally
guess I will
protectable
document where I go.
property interest
Great.
to the uncertainty
Okay,
that
now I'm kind of playing a
appears
little
in
too normally.
the exercise of discretion. The dissent, after suggesting various formulations of the entitlement in question, and ultimately contends that the obligations under the statute were quite precise, either make an arrest or, if that is impractical, seek an arrest
I do believe I'll need
warrant,
soul sand to
post
make
at 785.
another wart farm
The
later.
problem with this is that the seeking of an arrest warrant would be an entitlement to nothing but procedure, which we have held inadequate even
Oh,
to
this is probably
support
soul.
standing.
Yeah, soul
See
sand.
Lujan versus Defenders of Wildlife.
I think like 10 should be plenty.
504 U.S. 555,
Yeah,
1992.
seems good enough to me.
Much less
All
could it
right,
be
we're
the basis
gonna.
for a
Yep, we already
property
maxed out on that
interest.
front.
See post at
And we are not seeing a
771 to
fortress type thing.
772. Suitor.
Bone is huge
J.
though. Getting a bunch of bone to
Concurring.
grow my thing faster will be nice.
After the warrant is sought, it remains within the discretion of a judge whether to grant it.
I will take these
and
bone
after
blocks.
it is
This is really good
granted,
fertilizer for
it
the plants to make them grow faster.
remains within the
I don't know what you
discretion
are,
of the
bro, but I'm not
police
gonna mess with
whether
you.
and when to execute
I'm
it.
not
Point
playing with
11
you.
Respondent would
I have
have
no
been
reason to.
assured not ing,
Oh, he's
but
gone.
the seeking of a
He moved
warrant.
a little bit.
This
Okay.
is not the sort of entitlement out of which a property interest is created. Even if the statute could be said to have made enforcement of restraining orders mandatory because of the domestic violence context of the underlying statute, that would not. 10C post at 773. Entitlement to police protection.
Oh yeah, the game
IBID,
is.
entitlement to mandatory
The game is going through it
individual
right now.
protection by the local police
Oh
force.
my god, it is
Post
not liking
at
loading all this crap.
774.
I still don't know
A
what the
right
issue
to
is.
police assistance.
Oh my god, I'm getting
Post
like one
at
frame every now and again.
779. A citizen's interest in the
It
government's
is not.
commitment to
Oh my god,
provide
it's so
police
unhappy.
enforcement in certain defined
The game is breaking.
circumstances. Post at 789.
Jesus Christ.
Respondent's property
Still don't know what's
interest
causing
in the
that.
enforcement of her restraining order.
Maybe this will help me out
Post
somehow.
at
Nope. Okay.
790, 791, that the service of protection from her husband. Post.
Hey, I
at
got a bow. That'll make it easier to grab arrows for the rest of
792.
the game. Cool, I'll take it.
Interest in the
Okay, I'm kind of
enforcement
giving
of
up
the
on going that
restraining
direction for now.
order. 11.
My
The
dumbass really
dissent
did not
asserts
bring
that
a
the
sword on
police
this
would lack
process.
discretion in the execution of this warrant. Post at 785.
Wow, I need to heal. This is not
and
fun.
12, but cites no statute mandating immediate
I need to make a meaningful
execution.
effort to look in
The
one of these
General
directions.
Colorado statute governing arrest provides that police may arrest when they
Need
possess
to
a
look kind of like in
warrant
each
to
cardinal
command
direction a fair
ing
bit,
arrest.
and then give up and go back to the beginning.
Colorado Reverend
And go the other
Stat
direction.
Section 16, 31021, Lexus 1999. 545 U.S.
I do feel like I'll be more likely to find stuff.
Unit 76 Uruguayan
Oh
pesos.
my god, the game really does seem to
March
hate
26th,
loading in the nether
08,
recently. I don't know what the issue is.
21:17 and 18 seconds.
Computer's fine. It's not getting
Pages
that much utilization
PGT.
at all.
Open. Cite as 545 U.S. 748.
Holy cow. I've got to
2005.
rein it in, I guess.
Opinion of the court.
I guess I could limit the frame rate to my monitor, actually.
765.
But then, yeah, now it's limited.
Necessarily
Okay.
mean that state law gave respondent an entitlement to enforcement of the mandate.
Okay, now everything's
making the
red.
actions of government employees
Don't love
obligatory
that,
can
but
serve
everything is
various
red.
legitimate ends other than the conferral of a
Oh,
benefit
okay.
on a specific
Well, hey,
class
what
of
matters is that
people.
I'm covering distance.
See, e.g., Sandin versus Connor, 515 U.S. 472, 482, 1995.
Oh, go away, gas.
Finding
I
no
don't need anything that you
constitutionally
have.
protected liberty interest in prison regulations phrased in mandatory terms, in part because
Leave me alone.
U guidelines are not set forth solely to
Oh,
benefit
dead.
the
Okay, cool.
prisoner.
Moving on.
The
Let's try it
serving of
again.
public rather than private
Generic
ends is the normal
pickaxe
course of
and
the
the
criminal
tiniest bit of
law
food.
because
Just keep
creamy
doing it.
NAL acts, besides the injury
Other direction
they
this time.
do to individuals.
Okay, that's going to be the issue. I knew it. That was going to be the limiter.
Strike at the
I have
very being
consistently
of
had
society,
very bad luck
which
with
cannot possibly subsist, where actions
All right,
of
yep.
this
Now they're
sort
talking
are
about the
suffered
social
to escape
contract.
with impunity. 4W.
Yeah, how is it
Blackstone,
okay that the police
Commentaries
constantly
on the
ignored her
Laws of
and
England
faced
5,
zero consequences? How is that possible?
1769.
Like,
See
I
also
heard in an
Huntington versus
interview
Attray,
during the documentary about what
146
happened to this woman and her
U.S.
family.
657,
I heard the Castle Rock police chief or something, or sergeant,
668,
say that,
1892.
there was nothing the
This
police could have done to
principle
prevent this.
underlies,
Like, what?
for example,
How the fuck
a
has that become a standard
Colorado
thing you're allowed to
district
say?
attorney's discretion to prosecute a domestic assault, even though the victim withdraws her charge. See People vs. Cunfair, 102p.
Oh my God, get me off of this slow stuff. I'm losing it.
311 to 312. Colorado.
Oh, but the issue is I really
2004,
want that max render
Bank,
distance. Just turn off
Bender,
simulation. I don't really
J.
care about simulation.
Concurring in part,
Render stuff, though,
dissenting in
please, so I
part,
can
and
see
dissenting in part to the judgment.
possible location.
Respondents' alleged interest stems only from a state statutory scheme, from a restraining order that was authorized by and tracked precisely the statute on which the Court of Appeals relied. She does not
Okay, maybe it's
assert
over
that
here.
she has any common law or contractual entitlement to enforcement. If she was given a statutory entitlement, we would expect to see some indication of that in the statute itself.
No. Okay.
Although Colorado's
Am I
statute
above
spoke of protected
a
person,
fortress or whatever? Is it called a
such
fortress?
as respondent,
Yeah, it's
it
called a
did
fortress,
so
not a
in
not a
connection
stronghold.
with matters other than
Stronghold
a
is
right
something
to
else.
enforcement.
Holy
It
cow! I
said
can't see
that a
anything. Hey, that
protected
looks kind of like a
person shall be
bridge down there.
provided with a copy of a restraining order when it is issued. Section 18.
Tell me that that's one.
3.5.
Yes, I found it.
That
Oh
a
my
law
goodness, wonderful.
enforcement agency shall make all reasonable efforts to contact the protected party.
Oh, the lag
upon
is
the
actually
arrest
affecting
of
my
the
gameplay for
restrained
once. That's a
person.
bad outcome.
Section 18.
All right, there's the fortress. Now I just need a freaking way to get to it.
And that the
I'm gonna let the game
agency
chill for a second.
shall
It's
give to the
struggling, and
protected.
I still don't know what the issue is. 50
545
FPS,
US
48.
2. Unit 76.
It seems to be that like the amount of
pesos.
memory I've
March
allocated
26th,
is not
08,
good.
21:17 and 18 seconds.
Yeah, difficulty's still normal.
Pages
Okay.
PGT. Open.
Is there a way I can dedicate more
766.
VRAM to this?
Castle Rock v. Gonzales. Opinion of
I'm gonna
the
Google
court.
that, even though I'm mid play. I'd rather.
A copy of
make
the
this happen.
report it submits to the court that
let me
issued the
Google.
order. Section 18, 6803.5, 3e.
That's got to be it, I think.
Perhaps most importantly, the statute spoke directly to the protected person's power
More
to
VRAM
initiate contempt
in
proceedings against the
Minecraft
restrained person if the order.
Why does it just say saving world
issued
for you?
in a
Okay, yeah,
civil
because it doesn't say
action
that
or
for me.
request the prosecuting attorney to initiate contempt
You cannot manually
proceedings
allocate
if
more
the
VRAM to
order
Minecraft. It is
was
managed automatically by a
issued in
graphics driver and your game's
criminal
rendering
action.
engine. What?
Section 18, 6803.5, 7. The protected person's express power to initiate civil contempt proceedings contrasts tellingly with the mere ability to request initiation of criminal contempt proceedings, and even more dramatically with the complete silence about any power to request much less demand, that an arrest be made.
Uh,
The creation of a personal entitlement to something as vague and novel as enforcement of restraining orders cannot simply go without saying. Post at 788 N 16 Stevens J.
how do I
dissented.
add more memory?
We
So yeah, what is
conclude
this?
that
When I'm
Colorado
playing,
has not created such an entitlement.
when I'm playing, it says like 2 gigabytes of RAM or
See,
something in
even
the
if
top
you were
right.
to think otherwise
Right?
concerning the creation of an entitlement by Colorado, it is by no means clear that an individual entitlement to
Yeah,
enforcement of a
memory
restrain
out of
ing
that
order could
allocation
constitute
rate.
a
It's just
property
normal memory.
interest for
What's up?
purposes of the Due Process
Look
Clause.
at that
248. What?
Such a right would
Oh,
not,
cool.
of
I'm putting some
course,
books away.
resemble
Let's
any
see where the
traditional
ADHD starts.
conception of property.
Okay, how do I just allocate more RAM in
Although
general?
that alone does not disqualify it from due process protection, as Roth
How do I
and
allocate
its
more RAM in
progeny
Minecraft?
show, the right to have a restraining order enforced does not have some ascertainable monetary value, as even our Roth-type property as entitlement
So I need to
cases
go
have
to
implicitly required.
what?
Merrill, The Landscape of Constitutional Property,
JVM arguments.
86
How do I do
Virginia
this?
L. Rev. 885,
I'm gonna quit and reload Minecraft then.
964, 2000.
The hell am I
12
doing?
Perhaps most
Why do I have to do
radically,
this to make
the
Minecraft run?
alleged property. 12 The dissent suggests that the interest in having a restraining order enforced does have an ascertainable monetary
Why do I have to like
value,
rice
because
Minecraft to make
one
it work?
may
This is insane.
contract with a private security firm
Okay.
to provide
What
protection
am I doing?
for one's
I'm
family. Post at
open Minecraft launcher, go to installations tab, select your
773,
version, click more options.
790,
Installations.
791, and N19.
Installations?
That is, of course,
Okay, and
not
then I'm
as
gonna
precise.
edit it. And
545
what am I gonna
US
do?
2.
More options.
Unit 76 Uruguayan pesos.
Use 1
March
GC.
26,
Oh goodness.
08,
JVM arguments.
2117
XM
and 18
2G. I'm gonna give it
seconds.
8 gigs of
Pages
RAM.
PGT. Open.
Oh, is that gonna change anything for me or what?
Cite as 545
XMX8G.
748.
Yeah, I'm gonna give it 8 gigs of
2005.
RAM. We'll see what it does with that.
Opinion of the
It can take
court.
as much as it wants. I don't care. I've got plenty for it.
767.
Play.
Interest here arises incidentally.
All right, let's see if that
not out of
undoes this
some new
issue.
species
And
of
I'd stop getting this
government
weird
benefit
stuttering.
or service, but out of a function that government actors have
I've
always
performed.
performed,
Ooh, I've got
to
some
wit,
snacks here.
arrest
because I haven't eaten much
people who
today.
they have probable cause to believe
What
have
have I eaten today?
committed a criminal offense. Point 13. The indirect nature of a benefit was fatal to the due process claim of the nursing home residents in O'Bannon v. Town Court Nursing Center, 447 U.S. 773, 1980. We held that
It does have more
while the
RAM allocated to
withdrawal
it now.
of direct benefits, financial payments under Medicaid for certain
Max
medical
frame rate. Go for it,
services
buddy.
triggered due process protections.
Just freaking
ID
do it.
At 786,
Why do you have to rice Minecraft in the year of our Lord
787,
2025?
The same was not true
Why is
for
that
the
necessary?
Indirect benefit S conferred on Medicaid patients.
Okay,
when
good
the
God. How do I
government
even...
enforced
I don't even think
minimum
this is the right choice for
standards
now.
of
I think
care
what I want to
for
do is
nursing home
leave myself a nice
facilities,
little trail
ID.
to follow.
At 787 A, an indirect
And
and
then try and
incidental
get back
result
to
of the government's
spawn, which I don't
enforcement
think I
action
can. I actually
does
have no
not
idea where I
amount
am
to a
right now.
deprivation of any interest in life, liberty, or property. Ibid.
I think I'm just gonna die and come
In
back.
this case,
I really don't
as
want
in
to waste time
O'Bannon,
looking.
T. He
Compared
simple
to just
distinction between
remembering the
government
route.
action that
I'm gonna
directly
remember the route
affects a
manually.
citizen's legal rights, an action that is directed against a third party and affects the citizen only indirectly or incidentally, provides a sufficient answer
Okay,
to
so this is this
read.
direction to go.
Respondents' reliance on cases that found government provided. As the analogy between public and private schooling.
And
that
this
the
is why I need to
dissent
learn to stop doing
invokes.
that.
Post at 791 N19.
Okay, so it looks like I went this way.
Probably could have hired a
And I'm gonna go this way.
PRI firm to guard
Yeah, this is
her
the argument that they
house,
say. They
to
like
prevent her
she could
husband from coming
just
onto the
hired a
property,
private guard, but
and
like
perhaps even to search for her husband
a person
after
might
she
not even think of
discovered
that.
her children were missing.
Okay, almost fell.
Her alleged entitlement here,
Well, I really did
however,
not leave
does
a trail
not
for myself to
consist in
follow,
an
did I?
abstract
That was
right
a
to
stupid choice.
protection, but, according to the dissent, in enforcement of her restraining
Oh,
order through
okay.
the
I
arrest
see dirt
of her
over there.
husband, or the seeking of a warrant for his arrest, after she gave the police probable cause to believe the restraining order had been violated.
This is how I fucked up my first speed run. I
private
thought
person
that
would
like if
not
I
have
didn't
the
see
power
it
to arrest
soon, it was
under
just going to
those
be further away, but that's not at all what was
circumstances
going
because
on.
the crime would not have occurred in his presence.
Is this it? I think this is it. It's down there, isn't it?
Colorado
It is.
Reverend
Okay, I now
Stat
know the route.
Section 16,
It'd be nice to just build
Lexus
to there instead of worrying
1999.
about it, but I'm going to try to
And,
visually
needless to say,
remember
a
this route.
private person would not have the power to obtain
An arrest warrant. Yeah, a private person can't make that happen. That the police has a monopoly on justice. Maybe that's the language they want to use instead of violence, but they have a monopoly on justice, on the process of justice.
Or non-prosecution of another. Linda R. S. V. Richard
Issue.
D.
Where the hell is the portal again?
410
I've lost it.
S. 614, 619,
Uh-oh.
1973.
He's angry. He's going to yell at me and explode stuff.
545 US 2.
Okay, so I really have to like go all the way over there.
Uruguayan pesos. March 26th, 08, 21,
It's down here, no? Oh my god, I messed up.
Seconds.
No, it was Netherrack, where the portal is.
768. Castle Rock v. Gonzales.
I'm lost again. I'm giving up. Cool.
Opinion of the court.
All right. This time we're just gonna do it really well. That's what I'm thinking.
ID at 788. The O'Bannon court expressly noted, ibid, that the distinction between
Okay. How are we gonna do this? What's the plan? What's the plan?
Distinguished Memphis Light, gas.
Are we just gonna do a full run? Maybe. I'm thinking that's what I'm gonna do. I think I'm gonna do a full run. I'm doing a full run. I'm gonna regret it.
1970.
And all the gear that I'm about to waste.
One of the government services cases on
when
which
I inevitably die.
Post
I'm just gonna freaking go for it.
3. We conclude, therefore, that respondent did not, for purposes of the due process clause, have a property interest in police enforcement.
So again, they're going to say that she had no right to the
unnecessary to
the protection order.
The Court of Appeals determination 366.
I need way more gear than this. Sand is okay. Sandstone should work, I think, for what I'm thinking of.
That the town's custom or policy prevented the police
a golden apple is
from
who would be
giving her
good.
due process when they deprived her of that owl-legged interest.
And now I need
American
a stupid number of
In's Company
sticks.
v.
I'm gonna be lighting up everything.
526 U.S. 40 61 1999.
I don't know what my dogs are barking about right now. In the game.
In light of today's decision,
couple of stacks of that. I think I'm good. I genuinely think I'm good. Except it'd be nicer to build the bridge to the place out of cobblestone. But it would be a lot of cobblestone.
Procedural nor in its substantive manifestations. This result reflects our continuing reluctance to treat the 14th Amendment as a font of tort law.
Yes. They refuse to use the 14th Amendment as a, hey, people can't threaten each other's life, liberty.
1981, quoting Paul versus Davis, 424 U.S. at 701. But it does not mean states are powerless to provide victims with personally enforceable remedies.
But why not make that universal to the whole country? You believe in this country to be incredible, to be exceptional, to be supreme. Then why not have it be a country where the police have an obligation to protect people? Basic shit.
Tem
This
by
is this.
which
It just
police
it reads when you
departments
say
are
it aloud,
generally
and you're
held
like,
financially
oh, imagine a
accountable for
country where police have
crimes
no
that
obligation to
better
protect people.
policing might
Oh,
have.
you'd be like, oh, that's like a shitty sci-fi dystopian
14
novel. Ha
because we
ha. Like
simply
what
do
a,
not address whether the process would have been
what a savage
adequate if
society and culture
respondent
that
had
must
had a
be. But that's just the
property
U.S. That's
interest.
just
The
us.
dissent is correct to note that we do not contest the point post at 774. Of course, we do not accept it either. 545 US 2. Unit
Either there's a
76
wandering trader or a
Uruguayan
witch out here that's gonna kill
pesos.
me.
March 26,
I don't know.
08, 21, 17
All
and
right, all right, all
18
right.
seconds.
Let's do
Pages
this.
PGT.
This.
Open.
What are the ways that I can head?
Cite as
There's that way,
545 U.
and then there's this way. This way is the right way.
748, 2005.
I'm gonna build the most flawless stairs you've ever seen to make
Suitor
my own life easier.
J. Concurring. 769.
I'm making some wonderful freaking stairs over here. Is what
The
I'm doing
people
to
of
start.
Colorado are free to craft such a system under state law.
Yeah, but why
CF
not
Deschamps,
say, okay, this entire country is
489
one
US at 203
where people have a
115,
reasonable
the judgment of the
expectation
Court of Appeals is
that the
reversed.
police are going to do their job and protect them.
Justice Souter, with whom Justice Breyer
Well,
joined,
we should let the states
concurring.
decide that. Dude, this is not one of
Agree
those
with the
things where it's
court
just
that
like,
Jessica Gonzales
we need to not give the
has
states
shown
too much
no
power.
violation of an interest
You're
protected
you're
by
giving the police less
14th
power.
Amendment's due process clause.
If you're really into this
and
whole
I join the
libertarian
court's
bullshit,
opinion. The court
then
emphasizes the traditional public focus of law
don't
enforcement
allow
as
a police
reason
force to
doubt that
exist
these particular
that
legal
cannot do their
requirements to
job.
provide
That is its
police
own
services,
neglect is a
however
kind of abuse,
unconditional their
right?
form,
So if you're bothered by abuse of
presuppose
power, you should be
enforceable
bothered by
individual
neglect as
rights
well.
to a certain level of police protection. Ante at 764 to 765. The 15 in Colorado, the general statutory immunity for government employees
Just get rid of qualified immunity. Straight up, just get rid of it.
Omission causing injury was willful and
Yeah,
wanton.
willful or wanton. So neglect
Colorado
suddenly is an
Reverend
abuse.
Stat,
It is.
Section 24, 10, 118, 2A, Lexus 1999. Respondent's
It's funny though, I've seen
complaint does
plenty of
allege that the
cases where police
officers'
arrest
actions
parents
were
for neglect.
taken either willfully, recklessly,
But when the
or with
police neglect
such
their
gross
duties,
negligence
it's
as
okay.
to indicate wanton disregard and deliberate indifference to her civil
Dude, you can
rights.
only call it deliberate
Apt
indifference.
to pet
To
for
be like,
cert
oh, shut up, woman.
128A.
Your husband will come back. Just call us later when
The
something.
state case
Because
is
I'm sure it'll be
cited by the
fine.
dissent that
He
afforded
has a right to
cause
see
of
his
action
kids.
for police failure to enforce
He also
restraining
apparently had a right to
orders.
murder them.
Post at 782 to 700.
The right you generated by your neglect.
786 and 13 vindicate state common law or statutory tort claims, not procedural due process claims under the federal Constitution.
Okay, so it's down
See
here.
Donaldson versus Seattle, 65 Washington.
And I need to
Ave,
build an easy and effective
661,
way to go from there to here.
831p, 2D 1098,
Yeah, that hurt.
1992. City could be liable under some circumstances for per se negligence.
Leave me
in
alone,
failing
skeleton.
To meet statutory
I want nothing to do
duty
with you.
to arrest. Matthews versus Pickett County, 996 S. W. 2D 162, Tennessee 1999. County could be liable under Tennessee's Governmental Tort Liability Act where restraining order created a special duty. Campbell versus Campbell, 294 N. J. Super. 18, 682A, 2D 272, 1996. Rejected
Oh, that
for
hurt. Ow,
specific
okay, I need to
defenses
not get
under the
myself
New
killed right
Jersey
now.
Tort Claims Act in negligence action against individual OFFI SARES, Soroschetti v. New York, 65 N. Y. 2D 461, 482 N. E. 2D 70, 1985. City breached duty of care arising from special relationship between police and Victim, Nearing vs. Weaver, 295 Oregon
God damn it, leave me
702,
alone, skeleton.
670p, 2D
Man, I haven't even checked to see if this fortress
137,
has the things I need. Apparently sometimes they can be
Bank.
empty, so that would be really bad.
Statutory duty to individual plaintiffs arising independently of tort law.
Hopefully lava
duty
doesn't
of
come out
care.
while I do this and then murder me.
545 US 2. Unit, 76 Uruguayan pesos, March 26, 08, 21,
Okay, I've got to be very careful with this
17
pickaxe now
and
because it's
18
just running the hell
seconds.
out.
Pages PGT, open.
Nope, that's not good. Leave me alone.
770. Castle Rock v. Gonzales. Suitor, J, concurring. Court also notes that the terms of the Colorado statute involved here recognize and preserve the traditional discretion afforded law enforcement officers. Ante, at 760 to 764, and N. 8. Gonzales's claim of a property right thus runs up against police discretion in the face of an individual demand
Issue,
to
I still am
enforce,
not
and
over there,
discretion to
of all
ignore an
places.
individual instruction
How am
not
I
to
getting over
enforce,
there? And how much material is that going to
because,
take?
say, of a domestic
If I use netherrack, I could
reconciliation,
risk everything
no
I
one
have.
would
I'm going to
argue
need
that the
cobblestone, so I have to
beneficiary
go
of a
back.
Colorado order like the one
Shoot.
here would be authorized to control a court's
Well, I think we're getting to
contempt
halfway in this
power or
document,
order
and
the
I am
police
not
to refrain
done
from
with this part
arresting.
yet. It's just not good.
These considerations argue against inferring any guarantee of a level of
I will
protection
eventually
or safety that could be
somehow
understood as
cover
the
this whole
object
route.
of a legitimate claim of entitlement. Board of Regents of State Colleges versus Roth, 408 U.S. 564.
Okay, where's the spot with the torch?
577.
Where my stuff actually? There it is. Okay.
1972.
First time I've
and the
ever
nature of
successfully
property
navigated back to my
arising
damn
under
portal.
Colorado law. Consequently, the classic predicate for federal due process pro.
Okay, building all these stairs was worth it. It's gonna make life
Protection
easier.
of
Coming back
interests under
10
state
times.
law is missing. Gonzales
I
implicitly
am unfortunately very hungry though. I need to
recognizes
eat food at
this
some
when she
point.
makes the following argument.
Okay, what is it I'm doing now? I
Ms.
am mining a
Gonzales
stupid
alleges
amount
that
of
she was denied the process laid out in the statute.
a bunch of cobblestone, right?
The
Do I have
police
more?
did not
No, I do
consider
not.
her
Don't have
request
much.
in
Oh,
a
I had another
timely
stack, but I'm gonna
fashion,
need more than that.
but
I know I'm going
instead
to.
repeatedly required her to call the station over several hours.
Okay,
The
let's do this then.
statute promised a process by which her restraining order would be given vitality through careful and prompt consideration of an enforcement request. Denial
just
of
need to,
that process
I don't know, 3 or 4 stacks of freaking cobblestone probably.
interest in the restraining order. Brief for
No, I'm
respondent
gonna use metal.
10.
It's gonna be faster.
The argument is unconventional because the state law Ben Fit for which it claims federal procedural protection is itself a variety of procedural regulation, a set of rules to be followed
Oh, this
by
one's far away.
officers
Very
exercising the
inconvenient.
state's executive power. Use. Gonzales does not claim to have a protected liberty interest. 545 U.S. 2. Unit, 76 Uruguayan pesos.
Don't know why it says that every time. Still don't know.
21,
Very weird that the
17
document sees
18
that somewhere in
seconds.
the whiteness.
Pages PGT, open. Cite as 545 U.S. 748, 2005. Suitor, J, concurring. 771. All reasonable means to enforce, arrest upon demonstrable probable cause, get a warrant, and so on, see ante, at 751 to 752. When her argument is understood as unconventional in this sense, a further reason appears for rejecting its call to apply Roth, a reason that would apply even if the statutory mandates to the police were absolute, leaving the police with no discretion when the beneficiary of a protective order insists upon its enforcement. The Due Process Clause extends procedural protection to guard against
Need more than that.
unfair deprivation by state officials of substantive state law property rights or entitlements. The federal process protects the property created by state law. But Gonzales claims a property interest in a state-mandated process in and of itself. This argument is at odds with the rule that process is not an end in itself. Its constitutional purpose is to protect a substantive interest to which the individual has a legitimate claim of entitlement. Olam vs. Wakinakona, 461 U.S. 238, 250, 1983. See also Doe vs. District of Columbia, 93 F. 3D 861. 868, CADC 1996, per curiam, Doe vs. Milwaukee County.
Okay, that's got to be enough. It just has to be, right?
903F, 2D 499, 502 to 503, CA 7 1990. In putting to rest the notion that the scope of an otherwise discernible property interest could be limited by related state law procedures,
I'm going to say
court observed that
all of my useful items and just get rid of them.
Substance and procedure are distinct. Property cannot be defined by
I'll take a pickaxe
provided for its deprivation.
but nothing else, because I'm very likely to mess up and die here.
V. Loudermill, 470 U.S. 532.
Okay, we're just going to take all of our stacks of cobblestone, and that's how we're going to get to this place each time.
Just as a state cannot diminish a property right,
and I guess I'll take a stone sword just in case.
By attaching less than generous procedure to its deprivation,
I'm an idiot. I'm totally going to die. This is going to be bad.
Neither does a state create a property right merely by ordaining beneficial procedure unconnected to some articulably substantive guarantee. This is not to say that state rules of executive procedure may not provide significant reasons to infer an articulable property right meant to be protected, but it is to say that we have not identified property. 545 U.S. 2. Unit 76.
This is what I hate about bureaucracy.
March 26th,
is that you can use semantics as an excuse to do extremely immoral things.
PGT, open. 772. Castle Rock v. Gonzales.
Where am I going?
Suitor, J.
Did I just get lost? That doesn't seem good.
With procedure as such. State rules of executive procedure, however important, may be nothing more than rules of
whatever I think will get me over there the best.
Thus, in every
frankly,
of property recognized by
it looks like I should start by just going straight over here, and I probably did not need to build
the property has been
the thing that I did.
From the procedural obligations imposed on state officials to protect it. Whether WEL Fair Benefits, Goldberg versus Kelly, 397 U.S. 254.
A skeleton's gonna hit me, I can tell.
1970. Attendance at public schools. Goss versus Lopez, 419 U.S. 565. 1975. Utility services. Memphis Light, Gas and Water Dive EV, Craft, 436 U.S. 1. 1978. Public employment. Perry versus Cinderman.
Leave me alone.
Whoa! US
oh my god, I swear.
1972.
Fuck you, go away. You almost got me. That was bad.
Barry v. Barchi, 443 U.S.
I really do not want to mess this up. I want to get this route built. I want to get in there, get a couple of blaze rods.
The property interest recognized in our cases has always existed apart
now the
from
question becomes, how do I get down?
Protection before the court has recognized a constitutional claim to protection
Hell
by
no,
federal
get away.
process. To accede to Gonzales's argument would therefore work a sea change in the scope of federal due process, for she seeks federal process as a substitute simply for state process. And she seeks damages under Reverend Stat Section 1979, 42 U.S.C. Section 1983, for denial of process to which she claimed a federal right. There is no articulable distinction between the object of Gonzales's asserted
Oh,
entitlement
ow,
and the
how,
process she
how?
desires
You
in
did
order
that
to protect her
from over
entitlement.
there?
Both amount to certain steps to be taken
Dude,
by
I
the
hate these
police to
things so
protect her
bad because of
family
this.
and herself.
Stop burning,
Gonzales's
Jesus
claim
Christ.
would thus take us beyond Roth or any other recognized theory of 14th Amendment due
Wow,
process
oh my God.
by collapsing the distinction between
Insane.
property
Insane that just happened. That thing just saw me from that far and hit me.
protected and the process that protects
I'm gonna have no
it,
hope of
and
getting
would federal
over. Oh, it just
eyes
despawned.
every
Good, I'm alright with that.
mandatory state law direction to executive officers whose performance on the job can be vitally significant to individuals affected. The procedural
Jesus
directions
Christ,
involved
that was
here are
awful.
just that. They
Alright.
presuppose no enforceable
mean,
substantive entitlement.
We're down
and
here,
Roth does
so.
not raise them to
Oh, it looks like I
federally
can get lower though,
enforceable
and I'm going to
status
keep
in
trying
the
to get
name
lower
of
if I
due
can.
process.
Minimize how much damage I take from the fall when I take it.
545 US 2.
Ooh, scary.
Unit,
We are getting down there.
76 Uruguayan
And I am not loving it.
pesos. March 26th, 08,
Issue. My pickaxe is beginning to
21:17
fail.
and 18 seconds.
Oh my god, my pickaxe
Pages
failed.
PGT.
Okay.
Open.
Looks like we're doing this.
Cite as 545 U.S. 748, 2005. Stevens, J. Dissenting. 773. Justice Stevens,
Just get
with
over
whom
there.
Justice
This one
Ginsburg
sucks.
joins, dissenting. The issue presented to us is much narrower than is suggested by the far-ranging arguments of the parties and their amici. Neither the tragic facts
Oh,
of
I
the
can't get down
case,
there.
nor the
There's no
imperchance of according
world where I
proper
have enough
deference to law enforcement
health to make that
professionals
jump and not
should
die.
divert our attention from that issue.
So
That
then,
issue is whether
what
the
should be my
restraining
route
order
moving
entered
forward?
by the
Oh my
Colorado
god, you did
Rado
not just
Trial
get me
Court
from
on
there.
June 4th, 1999,
Okay, let's lock the hell
created a
in.
property interest that is protected from arbitrary deprivation by the Due Process Clause of the 14th Amendment.
Yeah, this is not happening the way that I'd like it to.
It is perfectly clear, on the one hand, that neither the federal Constitution itself, nor any
No, leave me
federal
alone, you
statute
asshole.
granted respondent
You fucking
or her
asshole.
children
Get
any
off.
individual entitlement to police protection. See DeShaney v. Winnebago County Department of Social
Okay, no.
Services.
Yeah, this is not happening the way I'd like it to.
489 U.
Son of a
S.
bitch, that was rough.
189,
That was a bad
1989.
outcome.
Nor, I assume,
Fuck.
does any Colorado statute create any such entitlement for the ordinary
Holy hell.
citizen.
Okay. Go get that stuff.
On the
Hopefully.
other hand, it is equally clear that federal law imposes no impediment to the creation of such an entitlement by Colorado law. Respondents certainly could have entered into a contract with a private security firm, obligating the firm
But
to
no one
provide
would think to do
protection
that because they
respondents'
have the
family,
natural assumption
respondents' interest
that the
in
police
such
are
a
going to do
contract would
anything.
unquestionably
What was the point of
constitute
even getting it through the
property
US justice
within the
system, getting a
meaning of the
restraining
Due
order, if
Process
it just
Clause.
means nothing?
If a Colorado statute enacted for her bene
Yeah, I gotta be honest.
or a valid order entered by a
It's
Colorado
important to be
judge
angry with the right
created
things.
functional equivalent of such
But
a private contract
there's
by
just something
grant
so
ING
insidious about
respondent
systemic
an
violence in
entitlement
comparison to
mandatory
everything
individual
else.
protection by the local police force. That state-created right would also qualify as property.
What, did the only thing
entitled
that
to
broke, was it my
constitutional
sword?
protection. Do not understand
No way.
the
Okay, there's the
majority
sword.
to rule out the foregoing propositions, although it does express doubts. See ante at
Fuck you, skeleton.
766,
Okay,
T is
I need
by
a way
no
down.
means clear that
More
an
than anything, I
individual
just need a
entitlement to
way down.
enforcement of a restraining order could
And
constitute
this block area does not seem to go much further.
545 U.S. 2.
So I think maybe the right thing to do then is to
Unit
build down
76
and then go from there.
Uruguayan
But I don't have
pesos,
the gear for that,
March
so
26,
great.
08, 21, 17 and 18
Oh my gosh,
seconds.
this sucks.
Pages PGT.
I just want to get in there.
open.
I can't. Just building to it has been so much work.
774. Castle Rock v. Gonzales.
Leave me alone. Holy
Stevens, J. Dissenting. Property interest. Moreover, the majority does not contest, see ante, at 768, that if respondent did have a cognizable property interest in this case, the deprivation of that
shit.
interest
I feel like we should be
violated due
allowed, like,
process.
when they're actually discussing
As
this,
the court notes,
I mean, truly, like, as a
respondent has
group, they
alleged
should
that
be
she
recorded.
presented the
I want to know,
police
like,
with a
what real
copy
human
of the
beings said during
restraining
this.
order issued by the Colorado court and requested that it be enforced. Ante, at 751, N1. In response, she contends, the officers effectively ignored her. If these allegations are true,
They did effectively
a
ignore her
federal
because
statute,
they did. That
Stat
happened.
Section 1979, 42 U.S.C. Section 1983 provides her with
Wandering
a remedy
trader.
against the petty
Very weird.
Gionier, even if Colorado law does not.
All right.
See
Take as much gear as we
Cleveland
can.
BD of Ed V.
And
Loudermilk,
I just need to bring
470
many of
S.
these.
532, 1985.
There we go.
The central question in this case is therefore whether, as a matter of Colorado
A bunch
law,
of those.
respondent had a right to police assistance comparable to the right she would have possessed to any other service the government or a private firm might have undertaken to provide.
It's just no
See
excuse
Board
to
of
just ignore
Regents
her
of State Colleges
and let this
versus
happen. I
Roth,
don't.
408 U.
I mean, this is something. These are things I'm going to say no matter how many times I read a Supreme Court document. I'm always going to say, how can a system of bureaucracy
Property
justify this degree of
interests,
systemic
of
harm?
course, are not created
They-
by the
they can't.
Constitution. Rather, they are created and their dimensions are defined by existing rules or understandings that stem from an independent source such as state law, rules or understandings that cure certain benefits and that support claims of entitlement
Hey, what if I told
to
you
those
to
benefits.
literally die?
There
Yeah,
was a
perish.
time
That's
when
crazy.
our tradition of judicial restraint would have led this court to defer to the judgment of more qualified
tribunals.
in seeking the correct answer to that difficult question of Colorado law. Unfortunately, although the majority properly identifies the central state law question, in this case as whether Colorado law gave
You're kidding me.
respondent a right to
Perish.
police enforcement of the restraining order
Perish.
ante, at 758, it has chosen to ignore our settled practice by provide its own answer to that question.
Yeah, they could have just left it. It was
Before
originally
identifying
dismissed.
the F laws in the
Then
court's
it was
ruling on the
taken back
merits,
up again.
I shall briefly
And then the Supreme Court
comment
kicked
on
in
our
and said,
past
actually, we're going to
practice.
dismiss it again.
545 U.S. 2. Unit
I get how this had
76
constitutional
Uruguayan
purview,
pesos, March
but to just kind of
26,
consciously
08,
interpret it in
21,
such a
17 and
way I
18
consider mean
seconds.
and wrong is
Pages
just horrible.
PGT, open.
Can I keep
Cite
mining
as
down? That would be convenient and nice.
545 U.S. 748,
Where exactly does all this end?
2005. Stevens, J. Dissenting. 775.
There we go. Now I can keep going down.
The majority's decision to plunge ahead.
Should have just done
with
this in the
its own
beginning.
anal
I should
license of
just generally
Colorado
not
law
try
and
to
prudently departs from this court's
build
long-standing policy
methods to
of
get down. I
paying
should just
deference
go down.
to the views of a federal court as to the law of a state within its jurisdiction. Phillips versus Washington.
I'm really confused
Legal
as to why the
Foundation,
Colorado Supreme Court never touched this.
524
Like, what's up with that?
U.S. 156, 167, 1998.
Okay, so the real most important
See
question: do we
also
think
Bishop
I can
versus
tank
Wood,
that fall if I fall?
426 U. S 341, 346, and N 10.
I do not think I can tank that fall. I can tank that fall maybe.
Cases.
Nothing else.
This policy is not only
I could tank like that fall specifically and nothing
our
else.
belief that
I have no
courts
food,
and courts of
and I don't have
appeals
enough
are
health
better schooled
to
in
tank that
and
fall
more
right
able
now.
to interpret the laws of their respective states.
You're kidding.
Brockett versus
Why didn't I bring food?
Spokane Arcades Inc. for 72 U.S.
Great. All right.
491.
Here's what I'm gonna have to do. I'm gonna have to leave. I'm gonna have to come back again.
1985.
To go get a bunch of food.
Cromwell,
Try and tank that fall.
326 U.S. 620. 629 to 630.
Man, I'm getting tired. I need to start using chess in here and stop doing this bullshit.
Great deference to the views of the judges of those courts, who are familiar with the intricacies.
If I knew how to use the satchel bag thing, I would, but I really don't know how to use it well.
Accordingly, we have declined to show deference only in rare cases in which the Court of Appeals resolute tie-in of state law was clearly wrong or otherwise seriously deficient. See Brockett, 472 U.S. at 500 N9.
And I'm out of food. Okay, we're gonna have to see if I can do that jump.
518 U.
I think what I should do is make a chest.
137, 145, 1996 per curiam.
Start using chess.
Unfortunately,
that's pretty obvious. I
the
need to do
court
that.
does not even attempt to demonstrate that the 6-judge en banc majority was clearly wrong in its interpretation of Colorado's domestic restraining
Don't really know why I'd make
ING
two, but I
order
guess I will.
statute.
There, fuck
Nor
ton of
could
bread. Let's go
such a
back.
showing be made.
I'll just drop my shit when I get back.
For it is certainly plausible to
Sword though.
construe,
Sword though
shall
might be
use
relevant.
every reasonable means to
Take the sword.
enforce a restraining order, and shall arrest. Colorado Reverend Stat Sections 18, 6, 803.
Colorado Revised Statute, not Reverend.
3A, B, Lexus 1999. Emphasis added, as conveying mandatory directives to the police, particularly when the same statute, at other times, tellingly employs different language that suggests police discretion. See Section 18, 6, 803.5, 6a. A peace officer is authorized to use every reasonable
Only
means
authorized.
to protect. Such
Not required,
peace
not
officer may
obligated to do their
transport.
job.
Emphasis added. Point 1. Moreover, unlike the Court of Appeals also looked to other provisions of the statute to inform its analysis. In particular, it reasoned that a provision that gave police officers qualified immunity in connection with their enforcement of 545 U.S. 2. Unit 76 Uruguayan
Everything goes
pesos,
in here.
March 26, 08, 21,
Everything but
17
netherrack. I'll
and
keep
18
netherrack on me,
seconds.
so I can
Pages
kind of tower back up
PGT.
maybe.
Open. 776. Castle Rock v. Gonzales. Stevens, J. Dissenting.
Okay, this guy's gonna hurt me.
Today's decision, the Court of Appeals
Oh,
was
wow,
attentive
okay.
to the legislative history of the statute.
So a fully
focusing on a
healthy character
statement by the
can
statute
clutch that
sponsor
fall,
in the Colorado
but not with a
House
skeleton in the way to
and
immediately hit them when they fall
at
down. Slight issue.
759 and 6, quoting statement, which it took to emphasize
Maybe I could take like an
E,
apple or something.
the importance of
Wonder
the
if
police's
one of the
mandatory
apples would've helped.
enforcement of Dome's tick restraining
I'm definitely gonna use
orders.
the enchanted golden one for the fight with the dragon.
366F,
Use the hell out of that.
3D1093,
But I'm gonna need 5 million arrows first. I'm gonna
1107,
fight probably the whole fight with arrows and a
CA
steel sword and nothing else.
2004, N Bank.
Nope, leave me
Far
alone.
from overlooking the traditional presumption of police discretion, then, the Court of Appeals' diligent analysis of the statute's text, purpose, and history led it to conclude that the Colorado legislature intended precisely to abrogate that presumption in the specific context. of
Abrogate is a big
domestic
word to be used in
restraining
this context,
orders.
bro.
That conclusion is eminently reasonable and, I believe, worthy of our deference. Point 2.
All right, skeleton, come and get me.
2.
Where are you at?
Even if the court had good reason
Out of the
to
way.
doubt the
It's
Court of
a good
Appeals'
enough thing for me.
determination of state law,
All right, now I have
it
to figure out a way
would,
to like
in
build.
my judgment, be a far wiser course to certify the question to the restraining orders. See Colorado Reverend Stat Section 18,
Oh, okay.
6803.55, Lexus 1999, supported the inference that the Colorado legislature intended mandatory enforcement. C 366F, 3D
What do I do if the
1093,
chest is on top of this though?
1108, CA 10 2004, N Bank. The court declines
It was
to
not.
show deference
Guess
for
I
the
got lucky
odd
this time.
reason that, in its view, the Court of Appeals did not draw upon a deep well of state-specific expertise, ante, at 757, but rather examined the statute's text and legislative history and distinguished arguably relevant Colorado case law. See ante, at 757, NN 4. This rationale makes a mockery of our traditional practice, for it is precisely when there is
Ow,
no
that hurt
state
again.
law on point that the presumption that circuits have local expertise plays any useful role. When a circuit's resolution of a novel question of state law is grounded on a conceitedly complete review of all the pertinent state law materials, that decision is entitled to deference. Additionally, it should be noted that this is not a case in which the Court of Appeals and the District Court disagreed on the relevant issue of state law. Rather, those courts disagreed only over the extent to which a probable cause determination requires the exercise of discretion. Compare 366F,
Great.
3D, at 1105 to
Oh, this is so
1110,
hard. I hate
with
it.
to pet.
All of this just to be able to run to the damn
For
thing
Cert 122A, District
and die
Court
30 times when I
Opinion,
do it. Guaranteedly.
545 US 2. Unit 76 Uruguayan pesos, March 26, 08, 21:17 and 18 seconds, pages PGT, OPIN. Cite as 545 U.S. 748, 2005. Stevens, J. Dissenting. 777. Colorado Supreme Court. Point 3 Powerful consideration support certification.
Fuck you, skeleton.
In this
Leave me alone.
case. First, principles
Leave
of
me alone.
federalism and
You come
comity
down here and I'm
favor
killing
giving
you.
the state's high court the opportunity
man.
to answer important questions of state law,
Fuck off.
particularly
alone.
when those questions implicate uniquely local matters such as law enforcement and might well require the weighing of
I genuinely
policy
don't know if I'm going to be able to
considerations
heal
for their
enough from
correct
this in a
resolution.
second.
Point 4 C. Elkins versus Moreno, 435 U.
Alright, I kind of refuse to die again, so
647.
it's time.
662.
I'm putting my gear on. I'm going
and
back out there.
16, 1978. SUA sponsor.
I'm going out there and I'm
define the
pissed.
question of state
Very,
law
very
because it
angry
is
indeed.
one in which state governments have the highest interest.
Soil.
CF
Okay, so as I
Arizonans
kind of
for
expected,
official
soul
English
sand
versus Arizona,
cushions a blow in
520
comparison.
U.S. 43, 77, 1997, through certification of novel or unsettled questions of state law for authoritative answers by a state's highest court, a federal court may save time, energy, and resources, and build a cooperative judicial federalism, brackets in original, point 5. See Colorado Rule App, Proc. 21.1.
Let's go. I've built that
Colorado
now.
Supreme
I can
Court
get to the
mains
damn
were
thing from
questions
here,
of law
probably.
certified to it by the Supreme
Oh my
Court
god, I
of
have
the
to build more
United
bridges.
States
I hate
or
this shit.
another
I'm
federal
so
court
tired.
if those questions, may be determinative of the cause, and, as to which it appears to the certifying court,
Looks like I've
there
accidentally
is no
figured out the pattern
controlling
for
precedent
building
in the
that, though, so that's a good
decisions of the
outcome.
Colorado
Alright, and it looks
Supreme
like
Court.
5 million pieces of
Foresee
soul
Westminster
soil or
versus
whatever.
Dogan Construction Company, 930
Okay, we're fucking doing it, though. I've got plenty of bread.
585,
If I can just minimize getting killed by skeletons and shit when I get in there, I
Colorado
should be fine.
1997, and
Can build a
Bank.
pathway to
In
it.
interpreting an ambiguous statute, the Colorado Supreme Court will
Oh my god,
consider
there are 20
legislative
skeletons.
history and the
Oh boy, I
consequences
sure
of a
hope there aren't 20
particular
skeletons. And then there's a
construction,
suspiciously
if it-
20 skeleton shaped
because we also presume
mob
that legislation
of
is
them
intended
coming
to
after
have
me right now.
just and reasonable effects. We
Thank
must
God they don't have
construe
fucking,
statutes accordingly and apply them so as to ensure such results. Additionally,
Yeah, I see you,
it
idiot.
is possible that
Guess
the
what?
Colorado Supreme Court would have better
Get
access
fucked.
to and greater
Get fucked.
facility with
Get fucked.
relevant
get
pieces
fucked.
of legislative history beyond
Hitting some of this right now?
those that we have before us. That court may also choose to give certain evidence of legislative
don't do this.
intent greater weight
Do not
than
do
would be
this.
customary for this court.
We are now waiting to heal.
C.E.G. Brief for Peggy Kearns
Heal
et
faster.
al. As Amici Curiae.
Give me
Bill
a
sponsor
fireproof
explaining the
slime
Colorado
thing
General
now.
Assembly's intent in passing the
Do it.
domestic restraining
No, you're in
order
the way of
statute.
the zombie pig. If I hit that, the whole run's over.
Citing similar considerations, the Second Circuit certified questions of state law to the Connecticut Supreme Court when it was faced with a procedural due
Give me a
process
magma
claim
cream,
involving a
you
statute
absolute
that
fucking
arguably
fiends.
mandated the removal of
Get outta
children
here
upon
I
probable
get murdered
cause of child
too hard.
abuse. See
Oh,
Sealed
there's a
versus
blaze.
Sealed,
I love that. That's wonderful. I'm so
332F,
excited.
3D51,
Perish, you
2003.
asshole. Thank
The
you.
Connecticut
God damn it,
Supreme
another
Court
skeleton.
accepted. 545
I think they can run
US2,
faster on soil than I can.
Unit
Or something.
76 Uruguayan pesos. March 26, 08, 21:17 and 18 seconds. Pages PGT.
Get
Open.
fucked, asshole.
778.
Yeah, I'm hurting, and there's no magma slimes, and I didn't get a
Castle
magma
Rock
cream.
v. Gonzales.
I think it's time. Let's go.
J. Dissenting.
I have plenty of gear for once.
Second, by certifying a potentially dispositive state law issue,
Are they up there?
court would
they
adhere
above me?
to its wise policy of avoiding the unnecessary adjudication of difficult questions of constitutional
Sound like they're above me to
law.
me.
C. Elkins, 435 U.S.
No way.
At 661 to 662.
Hell yeah. Found the spot.
citing
Oh no, leave me alone,
constitutional
skeleton.
avoidance
You're an
as a
asshole.
factor supporting certification.
You still coming?
Third, certification
You're just
would
pretending to be
promote
coming right
both
now.
judicial
Oh look,
economy
I'm gonna
and
block
fairness to the
this and just
parties.
build into their little
After
system
all,
ahead
the
of me.
Colorado Supreme Court is the ultimate authority on the meaning of Colorado law, and if in later litigation it should disagree with this court's provisional state law holding, our efforts will have been wasted and respondent will have been deprived of the opportunity to have her claims heard under the authoritative view of Colorado law. The unique facts
That
of
seems
this
bad.
case only serve to emphasize the importance of employing a
You leave me alone, you
procedure that will
asshole.
provide the correct answer to the central question of state law.
Get off of me.
See Brockett, 472
Oh,
US
shit.
at 510
Okay, all
O'Connor,
I'm doing is sitting
J.
and eating right now.
Concurring
Issue.
speculation
Do I
by a
even know where I
federal
am?
court about the mean.
I do know where I am, don't I?
ING of a state statute in the absence
Let's
of
give myself a
prior
little
state court
guide. There we go.
adjudication is
Okay, I think the only logical thing to do
particularly
now is
gratuitous
to build
when,
a
as is the case here,
spot for
the
a
state
chest
courts stand willing
and
to address
start
questions
putting
of
shit
state
into
law
chests.
on certification from a federal
I don't need
court.
90% of this crap right
0.6.
now. Not while I'm fighting.
Certification and held that the provision
I
was
need
discretionary,
a blaze rod.
not
I need
mandatory.
food. And I need a sword.
See Teresa
and a
T.
pickaxe to get around.
V.
Oh,
Regalia.
and that.
270.
I need lots of stuff, and I'm just stupid. Cool. Alright, that's taken care of. So what am I doing now? Blocking this.
428, 2005.
Ooh, still blocking
6. The
this, it looks
court is
like.
correct that I would take an anyone but us approach, ante, at 758 and 5, to the question of who decides the issue of Colorado law in this case. Both options that I favor, deferring to the circuit's interpretation or, barring that, certifying to the Colorado Supreme Court, recognize the comparative expertise of another tribunal on case tie-ins of state law.
Okay.
And both options offer their own efficiencies. By contrast, the court somewhat overconfident, only us approach lacks any cogent justification. The fact that neither party requested certification certainly cannot be a sufficient reason for dismissing that option. As with abstention, the considerations that weigh in favor of certification, federal-state comity, constitutional avoidance, judicial efficiency, the desire to settle correctly a
Oh my
recurring
gosh, leave me
issue
alone.
of state law, transcend the interests of individual litigants, rendering it imprudent to cast them as gatekeepers to the
Nope.
procedure.
I don't have the health for this.
C. E.
Oh,
G.
nope, that's what I mean, that's what I mean, that's what I mean, that's what I mean. Oh, I'm dead. I hate this shit.
U.S. 647, 662.
I don't have magma creams to make fire
1978,
resistance materials.
certifying state law issue.
Oh, and I haven't
absent
slept
a
forever in the
request
game,
from
so the things are
parties.
coming after me, great.
Aldrich. 545.
Alright, I just need to get back there
US2.
again.
Unit 76 Uruguayan pesos. March 26, 08.
I also think I am not beating the Ender Dragon again. I've been streaming for 2.5 hours. I do not believe I am beating the Ender Dragon.
Cite as
What's up?
545 U.S.
No, I'm still reading.
748.
It's gonna be a while.
2005.
I'm at page
Are you rereading the whole thing?
32 of 46. Yes, I am. We have now finally started the dissenting, which is good.
I think I might just keep loading up the bookshelves if that's okay. Unless
Okay.
you want me to be-
No, go ahead.
Okay. Happy to sit in here for a bit with you.
Stevens J. Dissenting. I've been reading the dissenting for a bit, actually. Nope, that's concurring. And then we start the dissenting. I'm actually going to restart the dissenting so I can pay more attention to it. Is that what page I'm on? Okay. I think I'm actually going back a little bit, but I don't really
Colorado
care.
Supreme Court. Point 3. Powerful considerations support certification in this case. First, principles of federalism and comity favor giving a state's high court the opportunity to answer important questions of state law, particularly when those questions implicate uniquely local matters such as law enforcement and might well require the weighing of policy considerations for their correct resolution. Point 4. See Elkins versus Moreno, 435 U.S. 647. 662, N. 16, 1978, SUA spont certifying a question of state law because it is one in which state governments have the highest interest. Cf. Arizonans for of official English versus Arizona, 520 U.S. 43, 77,
Damn it, there's a skeleton.
1997. Through certification of novel or unsettled questions of state law for authoritative answers.
Why
by
are there
the
so many
state's
free
highest
roaming
court,
blazes right
the
now?
federal court
Oh
may
my god,
save
I
time,
will die before I
energy,
get to my
and
gear again.
resources, and hell, p. Build a cooperative judicial federalism.
Shit.
Brackets in original. Point 5. See Colorado Rule App, Proc. 21.1a. Colorado Supreme Court may ensure questions of law certified to it by the Supreme Court of the United States or another federal court if those questions may be determinative of the cause, and
I don't need everything,
as
I
to
just
which
need
it
enough
appears to
material.
the certifying court there is no controlling precedent in the decisions of the Colorado Supreme
Thinking the
Court.
option is just start kicking ass.
Foresee Westminster versus Dogan Construction Company,
Kicking
930p,
ass is not going to work.
2D 585, 590,
I need a
Colorado
shield really bad,
1997,
clearly.
N. Bank, in interpreting an ambiguous
I need a
statute,
shield very, very, very
the
badly.
Colorado
Indeed.
Supreme Court will consider legislative history and the consequences of a particular construction, IBID. Because we also presume that legislation is intended to have just and reasonable effects, we must construe statutes accordingly and apply them
Can I really
so
not kill a
as to
single
ensure
one?
such results. Additionally, it is
I have to be
possible
smarter.
that the Colorado Supreme Court would have better access to and greater
If I could build like a
with
right angle to hide
relevant
behind, it would
pieces
help.
of legislative history beyond those that we have before us. That court may also choose to give certain
Oh great, I'm about to die again. I love
evidence
that.
of legislative intent greater weight than would be customary for this court. See, e.g., brief for Peggy Kearns et al. As Amici Curiae, bill sponsor explaining the Colorado General Assembly's
What the hell
intent
is going on in this
passing
game
the
right now?
Domestic Restraining Order statute.
Holy shit.
Citing
Why is this part so hard?
considerations,
Every
the
time.
Second Circuit certified questions of state law to the Connecticut Supreme Court when it was faced with a procedural due process claim involving a statute that arguably mandated the removal of
Nice.
children upon probable cause of child abuse.
I don't know how many of those I need. I just need a
Sealed
bunch.
versus sealed. 332
Let's really try to understand how many I need.
3D
Each of these
51,
makes
2003.
2 blaze rods. 2
The
blaze powders.
Connecticut
I'm gonna need
Supreme
12.
Court accepted. 545 US 2. Unit 76 Uruguayan pesos. March 26, 08, 21:17 and 18 seconds. Pages PGT. Open. 778. Castle Rock v. Gonzales. Stevens, J. Dissenting.
That's why I'm getting killed?
Second,
Because there's
by
another one over here?
certifying a potentially dispositive state law issue, the court would adhere
More
to
rods.
its
That's a
wise
good outcome.
policy of avoiding the unnecessary adjudication of difficult questions of constitutional law. C. Elkins, 435 U.S. at 661 to 662, citing constitutional avoidance as a factor supporting
No, I'm not gonna make it.
certification. Third, certification would promote both judicial economy
Whoa,
and
dodge
fairness
it, dodge
to
it,
the
dodge it,
parties.
bro. Oh my god.
After all, the
Huh.
Colorado Supreme Court is
This
the
sucks.
ultimate authority on the meaning of Colorado law, and if in later litigation it should disagree with this court's
Shit.
provisional state law holding, our
Sucks.
efforts will have been wasted and respondent will have
I don't
been
even have
deprived of
any
the
Eyes of Ender yet.
opportunity to have her claims
No
heard
Enderman
under
dead.
the authoritative view of Colorado law. The unique facts of this case only serve to emphasize the importance of employing a procedure that will provide the correct answer to the central question of state law. See Brockett, 472 U.S. at 510, O'Connor, J. Concurring, speculation by a federal court about the mean. Ing of a state statute in the absence of a prior state court adjudication is particularly gratuitous when, as is the case here, the state court stands
willingly to address the questions of state law. So
So
the Supreme Court made purview just to say no when they could have just let it be, left the question open, and knew that Colorado was going to probably fix this. But they went out of their way to get purview and say no, cops are not obligated to do anything. They like went out of their way to say no. And Steven's like, why are we even doing this?
Correct that I would take an anyone but us approach, ante, at 758 N5 to the question of who decides the issue of Colorado law in this case. Both options that I favor, deferring to the circuit's interpretation or, barring that, certifying to the Colorado Supreme Court, recognize the comparative expertise of another tribunal on
Issues. I
case
don't really know where
tie-ins
I'm
of
going
state
next.
law.
I go here.
And both options offer their own efficiencies. By contrast, the court's somewhat overconfident,
Oh my
only us
God.
approach lacks any cogent
Why are there multiple of these in
justification.
one place?
The fact that neither party requested certification certainly cannot be a sufficient reason for dismissing that option. As with abstention, the
Perish.
considerations that weigh in favor of certification,
Alright, maybe I can get in the zone and kill like
federal-state
2 or 3 of
comity,
these at a time, maybe.
constitutional avoidance, judicial efficiency, the desire to settle correctly a recurring issue
Cool.
of state
This will be a
law,
place to hide behind.
transcend the interests of individual litigants, rendering
Nice.
it
Okay.
imprudent to cast
Alright,
them
we're
as
good. We're good. We might do it.
gatekeepers to the procedure.
As long as it doesn't spawn like
C.E.G.
4, it only
Elkins
spawns 1 or
versus
2 at a time, I
Moreno,
should be good.
435 U.S.
Just do this for a bit until we have like, I don't know, 12 of these or something.
662, 1978, certifying state law issue absent a
do this
request
for a
from the
while.
parties. Aldrich.
Finally, we're in the zone. In zone. We got it rolling.
545 U.S. 2. Unit 76 Uruguayan pesos. March 26, 08, 2117.
Yeah, lucky. It's one that's already
18
contained.
seconds. Pages PGT. Open. Cite as 545 U.S. 748, 2005.
Oh no. You
Stevens,
gotta dodge this.
J.
Hide here while it goes.
779.
No. No, no, no. No, no, no.
Three
Bad. Bad outcome.
flaws
Bad
in the
outcome. Bad
court's
outcome. Bad
rather
outcome.
Superficial analysis of the merits highlight
Shit, what am I supposed to
the
do
unwisdom of
about
its
that?
decision to answer the state law question de
Nope.
novo.
Very bad. Very bad. All this is bad. This is all horrible.
First, the
Generally
court
not good
places
outcome.
undue weight on the various statutes throughout the country that seemingly mandate police enforcement but are generally understood to preserve police discretion. As a result, the court gives short shrift to the unique case of a mandatory arrest, statutes in the domestic violence context. States passed a wave of these statutes in the 1980s and 1990s with the unmistakable goal of eliminating police discretion in this area. Second, the court's formalistic analysis fails to take seriously the fact that the Colorado statute at issue in this case was enacted for the benefit of the narrow class of persons who are beneficiaries of domestic restraining orders, and that the order at issue in this case was specifically intended to provide protection to respondent and her children. Finally, the court is simply wrong to assert that a citizen's
Interest in the government commitment.
interest in the government's commitment to provide police enforcement in certain defined circumstances does not resemble any traditional conception of property, ante, at 766. In fact, a citizen's property interest in such a commitment
Let me read this.
is
This
just
section
as
seems
concrete and
really
worthy of
heavy.
protection as
Finally, the court is simply wrong to assert that a citizen's interest in the government's commitment to provide police enforcement is certain in... Okay, well, I'm going to try this again. Finally, the court is simply wrong to assert that a citizen's interest in the government's commitment to provide police enforcement in certain defined circumstances does not resemble any traditional conception of property. In fact, a citizen's property interest in such a commitment is just as concrete and worthy of protection as her interest in any other important service the government or a private firm has undertaken to provide. That's the common sense response, and yet somehow only 2 justices came to that conclusion. Oh. Jeez. Jesus. Okay, back to reading. Back to reading.
As her interest in any other important service the government or a private FIRM has undertaken to provide. In 1994, the Colorado General Assembly passed omnibus legislation targeting domestic violence.
Oh my
The
god.
part
How many
of the
more of these things do I think I should
legislation at
make?
issue
I
in
really
this
don't know.
case
I think
mandates
12 would be a good
enforcement
number.
of a domestic restraining order upon probable cause of a violation. Section 18, 6803.5(3), while another part directs that police officers shall, without undue delay, arrest a suspect upon probable cause to believe that a crime or offense of domestic violence. 5. Aldrich, 375 U.S. 249, 1963, per curiam, same, see also 17 A.C. Wright, Miller, and E. Cooper, Federal Practice and Procedure Section 4248, page 176, 2D edition 1988. Ordinarily a court will order certification on its own motion. 545 U.S.
6.
2.
Halfway to pretty good to me.
Unit 76 Uruguayan pesos.
And then
March
Endermen are going to be a problem.
08, 2117
Unless I find that jungle biome where there's a million of them, but I don't think that's going to be enough.
PGT, open.
I just don't think it's going to happen easily.
780. Castle Rock v. Gonzales.
Gonzales.
Stevens, J. Dissenting. Has been committed.
How did you even spawn
Section
behind me? That's
18,
not fair or nice.
6803.6,
Or reasonable, really.
1.7 In adopting this legislation, the Colorado General Assembly
Whoa,
joined
stop.
a
Leave me alone.
nationwide movement
Of course,
states that
I
took
get 3
aim
feet
at the
away and it
crisis
spawns 20 of them.
police under
We're getting out of
enforcement in the
here.
domestic violence sphere by implementing mandatory arrest statutes.
Need to eat
The
now.
crisis of under-enforcement had various causes, not least of which
Wow,
was the
I have suddenly
perception by police
decided that I don't
departments
really
and
care
police
anymore, and I'm
officers
going to
that
take what I've got and
domestic
dip.
violence was a private, family matter and that
Uh-oh.
AR arrest
I
was
actually
to be
don't know where I'm
used as
going
a
anymore.
last
That's a bad
resort.
outcome.
SAC, Battered Women and the State, The Struggle for the Future of Domestic Violence Policy, 2004 Wisconsin L.
Yeah, it's over
Rev.
here.
1657, 1662 to 1663, hereinafter SAC, ID, at 1663.
Oh, I have
because
11.
these
That should be
cases
plenty.
were considered non-criminal.
Okay, now we just need to
Police
get back
assigned
up top, and not
domestic
die in the
violence
process.
calls low PRI
Which sounds
orally
surprisingly
and
hard.
often did not respond to them for several
Nope.
hours or
Wow,
ignored
get me the
them
fuck out of here.
altogether. In response to these realities, and emboldened by a well-known 1984 experiment by the Minneapolis Police Department, 8 many states enacted man. See Fuller and Stansberry.
I need to jump and read that.
1994
Many states enacted mandatory arrest statutes under which a police officer must arrest an abuser when an officer has probable cause to believe that a domestic assault has occurred.
Datary arrest statutes under which
that's
a police
common
officer
sense.
must arrest an abuser when the officer
And
has
an
probable
officer
cause to
failing to do
believe
that
a
should
domestic
very much
assault
be
has
cause.
occurred or that a protection order has been violated. Developments in the law, legal responses to domestic violence, 106 Harv. L. Rev. 1498, 1537, 1993.
Hell no. I'm killing this
The
thing.
purpose of these statutes was precisely to counter police resistance to arrests in domestic violence cases by removing or restricting police officer discretion. Mandatory arrest policies would increase police response and reduce batterer recidivism. SAC 1670.
Yes. Super common sense policy. The Supreme Court should be able to look at and be like, oh.
Its statute in 1994, it joined the ranks of 15 states that mandated arrest for domestic violence offenses and 19 states that mandated arrest for domestic restraining order violations.
Okay.
See
Slowly getting there, slowly
developments
getting
in the
there.
law, 106 Harv. L. Rev. At 1537
We just need to
and
not fall in lava.
68,
Need to
noting
get these back
statutes
to the
in
house,
1993,
back to the base.
and Miller, Institute for Law and Justice, a Law Enforcement and Prosecution Perspective 7, NN 74, 8, NN 90, 2003, http
Oh God, it's giving me a crazy link.
www.ilj.org/dv/dvawa2000.htm. As visited June 24,
The fact that policing in America is such that
and available
they
in the
just aren't
Clerk of
already
Court's case
obligated
file,
to arrest
list
abusers when they
ING
respond to
Colorado
calls
among the many states that
should just be
currently have
cause for
mandatory
questioning
arrest statutes.
how that isn't default.
Point 9.
The fact that this has to be legislated
Given
instead
the
of it being an
specific
expectation of
purpose
policing is
these
absurd.
statutes, there can be no doubt that the Colorado legislature used the term shall advisedly in its domestic restraining order statute. While
Alright, that's it. Blaze rods. Didn't even have to make the rest of this
Sponse's
crap.
arrest had a significantly greater impact on reducing
Wonderful.
domestic violence
And I'm generally
recidivism.
tired of playing by now,
The
but hey.
findings from the Minneapolis
deal.
study were
6
used
arrows.
by
I'm gonna
the
need, I don't know,
U.S.
100?
Attorney General in a
Probably.
report issued in 1984 that recommended, among other things, arrest in domestic violence cases as the standard law enforcement response. Footnotes omitted. See also Zorza, the criminal law of misdemeanor
Right, let's get
domestic
all the food we have in the
violence,
game right now.
1970 to 1990, 83J, CRML, and C, 46. 63 to 65, 1992, tracing history of mandatory arrest laws and noting that the first such law was implemented by Oregon in 1977. 9C
No, it just needs to
also
be nighttime
brief
at some
for
point.
International Municipal Lawyers Association et al. As Amici
Got a bunch of
Curiae
bone. I think I
6,
need a bunch of flint and a bunch of
Colorado is
feathers,
not
so I'm not
alone in
manually making
mandating
arrows.
the arrest of
Probably.
persons who violate protective orders.
So I can find chickens.
Some 19 states
No, it's not worth it.
require an arrest when a police officer has probable cause to believe that such orders have been violated. Collecting statutes.
Okay, I guess I'll keep the bones instead of turning them into food.
545 US 2. Unit 76
But what do you want?
Uruguayan pesos. March 26,
Nothing notable to me.
21,
Alright, leave me alone then.
17 and 18 seconds. Pages PGT.
Dogs, come on.
Open.
Let's go look for chickens, I guess.
782. Castle
Maybe
Rock
over there.
v. Gonzales. Stevens, J. Dissenting. Shall is probably best read to mean may in other Colorado statutes that seemingly mandate enforcement. Cf. Colorado Reverend Stat Section 31 for 112.
No normal person
Lexus
would have that expectation
2004.
that a police officer would not be
Police
obligated
shall
to respond.
suppress all riots, disturbances, and
Hey, Andrea.
breaches of the peace, shall apprehend all disorderly persons in the city. Emphasis added, it is clear that the elimination of police discretion was integral to Colorado and its fellow states' solution to the problem of underenforcement in domestic violence cases. Point 10. Since the text of Colorado's statute perfectly captures this legislative purpose, it is hard to imagine what the court has in mind when it insists on some stronger indication from the Colorado legislature. Ante, at 761.
Since the text of Colorado's statute perfectly captures this legislative purpose, it is hard to imagine what the court has in mind when it insists on some stronger indication from the Colorado legislature. It's about as strong as you could possibly say it already.
761. While Colorado case law does not speak to the question, it is instructive that other state courts interpreting their analogous statutes have not only held that they eliminate the police's traditional
How many
discretion to
goddamn
refuse
interesting
enforcement,
areas have spawned
but
in this
have
game? What is going on?
10C note.
Did Minecraft just update to get a lot easier for some reason?
A step toward eradicating domestic violence. But is it enough?
Look at that. That must be like an unused portal.
Rev 533,
Oh no, it's not.
541 to 542,
It's a cactus.
544 to 546, describing the problems that attend a discretionary arrest.
It's like a mega
regime.
desert. It's not even a
When
desert biome. It's like a
probable cause is
mega
present,
ultra-sized desert.
Police officers still frequently try to calm the parties and act as mediators. 3 studies found the arrest rate to range between 3% and 10%.
How the hell you can respond to a
when the
domestic
decision to
abuse
arrest is
call
left to police discretion.
and they dropped to 3 to
Another
10%?
study found that the police made arrests in only 13% of the cases where the victim had visible injuries.
In cases with visible injuries, they
Police
only acted
officers often
13% of the
employ
time?
irrelevant criteria such as the reason for the abuse or the severity of the victim's injuries in making their decision to arrest. Some OFFICers may feel strongly that police should not interfere in family arguments or lovers' quarrels. Such attitudes make police much more likely to investigate intent and provocation, and consider them as mitigating FAC. TORs, in responding to domestic violence calls than in other types of cases.
Do an armor trim. Bro, I don't know what that is. I do not need it.
Omitted.
Get out of here.
See also
string will be useful for a bow.
The mandatory arrest
Sure, string
law,
for a bow.
Police reaction. 16
Iron is great.
Pace L, Rev 97,
Smite.
98, 1995.
Apples, string,
CF
bones. Man, I really need
1671 to 1672.
feathers then.
Mandatory arrest policies
Mending. Oh, that'd be huge.
significantly increased the
Right,
number
get me outta
of
here.
arrests of batter heirs for domestic violence crimes. In New York City, from 1993, the time the mandatory arrest policy was instituted, to 1999, felony domestic violence arrests increased 33%, misdemeanor domestic violence arrests rose 114%,
Why am I this lost? Okay,
and
whatever.
arrests for violation of orders of protection were up 76%. 545 US 2. Unit, 76 Uruguayan pesos, March 26, 08, 21:17 and 18 seconds, pages PGT, open. Cite as 545 U.S. 748, 2005.
It's not something's on
Stevens,
fire.
J. Dissenting.
No, it's not my house.
783. Also recognize that they create rights enforceable against the police under state law. For example, in Nearing vs. Weaver, 295 Oregon 702, 670 p. 2D 137, 1983, N. Bank, the court held that although the common law of negligence did not support a suit against the police for failing to enforce a domestic restraining order, the statute's mandatory directive formed the basis for the suit because it was a specific duty imposed by statute for the benefit of individuals previously identified by judicial order. ID, at 707, 670 p. 2D,
I believe I'm quickly losing
140.11
location of my house, which is not
Matthews
good.
v. Pickett County, 996 S.W., 2D 162, Tennessee 1999. On certification to the Sixth Circuit, the court confirmed that the statute mandated arrest for violations of domestic restraining orders, and it held that the public duty defense to a negligence action was unavailable to the defendant police officers because the restraining order had created a special duty to protect the plaintiff. ID, at 165. See also Camp. Bell v. Campbell, 294 N. J. Super. 18, 24, 682 A, 2D 272, 274. 1996 Domestic Restraining Order Statute allows no
The murder that
discretion
thing.
with regard to arrest.
Okay.
T.
Where's
He
the,
duty
he's gone.
imposed on the
Alright, I'm too
police
slow.
officer
Great.
is ministerial. Donaldson vs. Seattle, 65 Washington App, 661, 670, 831 p. 2D 1098, 1103, 1992, generally. Where an officer has legal grounds to make an arrest, he has considerable discretion to do so. In regard to domestic violence, the rule is the reverse. If the officer has the legal grounds to arrest pursuant to the statute, he has a mandatory duty to make the arrest. To what extent the Colorado Supreme Court would agree with the views of these courts is, of course, an open question, but it does seem rather brazen for the majority to assume that the Colorado Supreme Court. 11. The Oregon Supreme
I
Court
believe I've
noted
messed up.
that the widespread refusal or failure
And I
of
am
police
lost.
officers to remove persons
Some pretty good
involved
gear
in
on me,
episodes
unfortunately.
of domestic violence was presented to the legislature as the main reason for tightening the law so as to require
I think it might be that over
enforcement of
there.
restraining orders by mandatory
Maybe.
arrest
I don't
and
know.
custody. Nearing 295 Oregon at 709. 670 p. 2d. at 142. 545 U.S. 2. Unit 76 Uruguayan pesos. March
Still
26, 08,
every time I hear that, it's so weird.
17 and 18 seconds. Pages PGT. Open. 784. Castle Rock v. Gonzales. Stevens, J. Dissenting.
Okay, oh, found my house. Good.
Would repudiate this consistent line of persuasive authority from other states. Indeed, the court fails to come to terms with the wave of domestic violence statutes that provides the crucial context for understanding Colorado's law. The court concedes that, in the specific context of domestic violence, mandatory arrest statutes have been found in some states to be more mandatory than traditional mandatory arrest statutes, ante, at 762, but that is a serious understatement. The difference is not a matter of degree, but of kind. Before this wave of statutes, the legal rule was one of discretion. As the court shows, the traditional, general mandatory arrest statutes have always been understood to be mandatory.
Might build an anvil at that rate.
See
Maybe not, we'll see.
At 760.
I'm gonna carry a bow on
The
me
innovation of the
and slowly
domestic
try to get as many
violence
arrows as
statute
possible.
was to make police
12
enforcement
is not nearly enough.
not more mandatory, but simply mandatory. If, as the court says, the existence of a protected entitlement turns on whether government officials may grant or deny it in their discertation, ante, at 756, the new mandatory statutes undeniably create an entitlement to police enforcement of restraining
Oh my gosh.
orders.
Can you make it 20 feet before some bullshit happens?
Perhaps recognizing this point, the court glosses over the dispositive question, whether the police enjoyed discretion to deny enforcement, and focuses on a different question, which precise means of enforcement, ante, at
Okay, we are cooked on this whole
were called for in this case.
Enderman situation. It's not happening.
But that question is a red herring. The statute directs that, upon probable cause of a violation, a peace officer shall arrest, or, if an arrest would be impracticable under the circumstances, seek a warrant for the arrest of a restrained person.
No, damn it. Day's already coming.
Reverend Stat Section 18, 680.
I wanted Enderman, damn it.
3,
Not a single one. It's
Lexus
ridiculous.
1999. Regardless of whether the enforcement called for in this case was arrest or the seeking of an arrest warrant, the answer to that question probably changed over the course of the night as the respondent gave the police more information about the husband's whereabouts. The crucial point is that, under the statute, the police were required to provide enforcement. They lacked the discretion to do nothing. 545 U.S. 2.
Nothing.
Unit 76 Uruguayan pesos.
That's still
March
annoying.
26th 08 2117.
I know. Am I more likely to find Edelman in the
pages
other
PGT
game?
open.
Probably, it looks like. Guess I'm gonna do that
Cite
then.
as 545 U.S. 748 2005. Stevens, J. Dissenting. 785. ING.12. The court suggests that the fact that enforcement may encompass different acts infects any entitlement to enforcement
5 more arrows.
with
Not bad.
indeterminacy. Ante at 763.
I really need a lot of stuff to
But
come
this
together correctly at the
objection
same
is
time
also unfounded.
in a speedrun.
Our cases have never required the object of an entitlement to be some mechanistic, unitary thing. Suppose a state entitled every citizen
Sure, this
whose
seems
income was under
fine.
a certain level to receive health care at a state clinic. The provision of health care is not a unitary thing. Doctors and administrators must decide what tests are called for and what procedures are required, and these decisions
How the
often
hell did this
involve
get in there?
difficult applications of judgment.
Alright, let's see
But
what I
it
can
could
do
not
now.
credibly be said that a citizen lacks an entitlement to health care simply because the content of that entitlement is not the same in every given
Wish my dogs could come
situation.
with me. That'd make life easier.
Similarly, the enforcement of a restraining
Alright,
order
where
is
can
not
I find
some
some
amorphous,
Enderman?
indeterminate thing. Under the statute, if the police have probable cause that a violation has occurred, enforcement consists of either making an immediate arrest or seeking a warrant and then executing an arrest. Traditional, well-defined tasks that law enforcement officers perform every day. 13. 12. Under the court's reading of the statute, a police officer with probable cause is mandated to seek an
I did not
arrest
mean to quit.
warrant
What the
if
hell?
arrest is impractical under the circumstances,
I meant
but
to
then
change the
enjoys
simulation
unfettered
distance.
discretion in
It's already maxed.
deciding
Everything is
whether
maxed.
to
What do I do?
execute that warrant. Ante at 764. This is an unlikely read ing given that the statute was motivated by a profound distrust of police discretion in the domestic violence context and motivated by a desire to improve the protection given to holders of domestic restraining orders. We do not have the benefit of an authoritative construction of Colorado law, but I would think that if an estranged husband harassed his wife in violation of a restraining order, and then absconded after she called the police, the statute would not only obligate the police
Yeah,
to
that is the
seek an
common
arrest
sense
warrant,
thing.
but also obligate them to
Execute it by making an arrest. This is just extremely common sense. Given that the statute was motivated by a profound distrust of police discretion in the domestic violence context and motivated by a desire to improve the protection given to holders of domestic restraining orders, we do not have the benefit of an authoritative construction of Colorado law. But I would think that if an estranged husband harassed his wife in violation of an order and then absconded after she called the police, the statute would not only obligate the police to seek an arrest warrant, but also obligate them to execute it by making an arrest. In any event, under respondents' allegations, by the time the police were informed of the husband's whereabouts, an arrest was practical and, under the statute's terms, mandatory.
Arrest. In any event, under respondents' allegations, by the time the police were informed of the husband's whereabouts, an arrest was practical and, under the statute's terms, mandatory. 13. The court wonders how the mandatory arrest paradigm applies to cases in which the offender is
Is
not
not present to be
arrested.
arrested. That in an attempt to
Ante
investigate
at
and find them should be
762.
made. Jesus.
Again, questions as to the scope of the obligation to provide enforcement. 545 U.S. 2.
Are
Unit
police obligated to protect you?
76
No.
Uruguayan
That is
pesos.
the Supreme Court's
March
conclusion.
26, 08, 21, 17 and 18 seconds.
Jesus Christ, I
Pages
haven't seen a single
PGT.
Enderman in forever.
Open.
Oh, that's gonna hurt. Okay.
786.
Well, at least I didn't die.
Castle Rock v. Gonzales.
Really? No Enderman? Like where?
Stevens,
Where?
J.
I know where they're hiding. They're hiding at
Vicente.
the end, but like, what the fuck?
The court similarly errs in speculating that the Colorado legislature may have
Oh, don't do this
mandated
bullshit.
police enforcement of restraining orders for various legitimate ends other than the conferral of a benefit on a specific
Okay,
class of
again,
people.
no Enderman.
Ante
This is like the
at
thing that gets me killed eventually.
765. See also Ibid, noting that the serving of public rather
Well,
than
give me this
private
arrow.
ends
It's
is
dumb
the
that you
normal
wouldn't.
course of the criminal law. While the court's concern would have some bite were we are far afield from the key issue, whether there exists an entitlement to enforcement.
There should be an entitlement to
In
enforcement.
any event, the court's speculations are off base. First, this is not a case like Donaldson versus Seattle, 65 Washington.
It's so fun to watch them
661,
fighting and debating in one document. It's like nice to see discourse on display, but it just makes it infuriating to see them be like, this case isn't about that. It's about something else that I'm sure will not have terrible consequences for all of society. And then it has terrible consequences for all of society.
100 yards of the family home.
Ridiculous.
But he continued to violate the order while his abduction of the daughters persisted.
Yes.
This is because the restraining order prohibited him from molest, ing, or disturb, ing, the peace of the daughters.
Yes.
See 366F, 3D, at 1143, Appendix to Descent
Hi,
of
why am I
O'Brien,
not seeing a single
J.
Enderman? What is up with this biome such that I
Because
wouldn't?
the scene of the violation was wherever the husband
It is on my
was
other
currently
playthrough. I bet it'd be
holding
done
the
by now.
daughters.
But
This case does not imply
kinda not
the
fair.
question of an officer's duties to arrest a person who has left the scene and is no longer in violation of the restraining order.
Huh?
Second, 2.
It's like, oh, it was illegal
The
for a
extent that
sec. It
arresting
just
the
isn't
husband
now.
was
What?
initially impractical under the circumstances, because his whereabouts were unknown.
Okay,
The
that's why you
Colorado
investigate
statute,
and find
unlike
him.
some other state statutes,
Jesus.
expressly addressed that situa tie-in. It
Required the police to seek an arrest warrant.
Third, the court is wrong to suggest that this case falls outside the core situation that these types of statutes were
No,
meant
this is
to
quite literally the
address.
core situation.
One of the well-known cases
Any
that
other argument sounds
contributed
like
to the
conscious
passage
ignorance
of
to the
these
issue.
statutes involved facts similar to this case. See Sorochetti v. New York City, 65 N.Y.
How many pages we got left? Not much, I imagine. Yep. 5-6 more pages. So, we'll be wrapping up here soon.
Circumstances.
And maybe I'll try and pull up
because
the,
his whereabouts were unknown.
Nah.
The Colorado
I'll edit it
statute,
myself instead of showing it on
unlike some other
stream.
state
The
statutes,
documentary about
expressly
this
addressed
woman and her
that
life.
situa tie-in. It required the police to seek an arrest
Yep,
warrant.
I'm not finding Enderman fast enough.
Third, the court is wrong to suggest that this case falls outside the core situation that these types of statutes were meant to address. One of the well-known cases that contributed to the passage of
Dang,
these
well, I guess
statutes
maybe I'll try and beat
involved
this game in
facts
another
similar to
playthrough.
this
It's been 3
case.
hours and I still can't beat the game. That's pretty bad.
See Sorochetti v.
Some people can do this for like a week
New
straight
York
and they'll get
City,
down to like 10 minutes
65
to beat the game.
N.Y.
So,
2D 461 for 67 for 82 N E 2D 70 74 1985 police officers at police station essentially ignored a mother's pleas for enforcement of a restraining order against an estranged husband
This is
who made
another?
threats about their 6-year-old daughter.
What is this case? Sorichetti versus New York City. This is a New York Supreme Court?
Hours later, as the mother persisted in her pleas,
It's found
the
mutilated.
daughter
Her
was
father having
found
attacked her.
mutilated, her father
That's-
having attacked her with a
Jesus
fork
Christ,
and a
it
knife
keeps
and
happening.
attempted to saw off her leg. Note,
Jesus.
1996 U. Rev.
No,
at
mandatory
539,
development of mandatory arrest statutes.
noting
Very
Sorichetti
appropriate
in
response
development of
by the state of New
mandatory
York.
arrest
Why
statutes.
did
See also
the
SAC
Supreme Court fail
1663.
to see that common
Citing
sense?
the police's failure to respond to domestic violence calls as an impetus behind mandatory arrest statutes. It would be singularly odd to suppose that in passing its sweeping omnibus domestic violence legislation, the Colorado legislature did not mean to require enforcement in the case of an abduction of children in violation of a restraining order. 545 U.S. 2. Unit 76 Uruguayan pesos, March 26, 08, 21:17 and 18 seconds, pages PGT, open. Cite as 545 U.S. 748, 2005. Stevens, J. Dissenting. 787.
Man, so I'm getting faster at these speedruns, definitely, with being
Faced
able to
with a
choose my
broadly
world,
drawn
or just
statute
randomly generate
directing,
one.
for example,
But I
that the
really beat her
police
out
shall
right after I get to the
suppress
nether.
all
It
riots.
kind of gets a lot
There is
harder.
little doubt that the statute
That's the
at
point,
issue
but
in this case conferred a benefit
I'm just not staying
on a
quick.
specific class of people, namely recipients of
Maybe I
domestic
should update
restraining
myself on the
orders.
modern strats and see
Here,
what people are doing
respondent applied for
to get
and
fast
was
times right
granted
now.
a restraining order from a Colorado trial
I only get
judge
exposed
who
to
found
Minecraft
the risk
speedruns in
of
very specific
irreparable
circumstances.
injury and found that
With
physical
the couple
or
of people I watch who
emotional
run.
harm would result if the husband were not excluded from the family home. 366
I'm currently just stuck
3D
waiting for it to be
at
nighttime.
1143, Appendix to Dissent
So
of O'Brien, J.
I'm just gonna let the game
As
sit
noted earlier, the
and
restraining order required that the husband
do
not
not much else.
molest or disturb the
Uh-oh.
peace of
If I click
respondent
away,
and the daughters, and it
the game
ordered,
assumes
with
that I'm
limited
not playing.
exceptions, that the husband stay at least 100
That's not
yards
good.
away from the family home. Ibid.14 It also directed the police to
Okay, maybe I'll make the
use
game
every
windowed real quick.
reasonable means to enforce this order, and to arrest or seek a warrant upon probable cause of a violation.
Nope, it
ID
auto
at
pauses the game.
1144. Under the terms of
Okay.
the statute, when the order issued, respondent and her daughters became protected person S. Dot. Section 18.
There we go. Okay, now the game's continuing in the background.
1.5.
What are you seeing
A
though? Like a half screen?
Protected person.
I messed up
means the
half screen.
person
I'm just
or
going to be chilling and
persons
look at stuff
identified in
while I
the
wait for
restraining
day to
order
pass,
as the
and I'm also
person
going
or
to.
persons for whose benefit the restraining order was issued. Point 15.
I'm also just going to pay more
statute
attention to
crime.
the last bit of this descent.
Analyze the knowing violation of the restraining order. Section 18, 6803.5, and, as already discussed, the statute, as 14. The order also stated, if you violate this order thinking that the other party or child named in this order has given you permission, you are wrong, and can be arrested and prosecuted. The terms of this order cannot be changed by agreement of the other party or the child. Run. Only the court can change this order. 366 F. 3D. At 1144. Appendix to Dissent of O'Brien, J. 15. A concern for the protected person pervades the statute. For example, the statute provides that a peace officer may transport, or obtain transportation for, the alleged victim to shelter. Upon the request of the protected person, the peace officer may also transport the minor child of the protected person, who is not an emancipated minor, to the same shelter. Section 18, 6803.56a. 545 U.S. 2. Unit 76 Uruguayan pesos, March 26, 08, 2117 and 18 seconds, pages PGT, Open. 788. Castle Rock v. Gonzales. Stevens, J., dissenting. Well as the order itself mandated police enforcement, sections 18, 6803.5, 3, A, B, point 16. Because the statute's guarantee of police enforcement is triggered by, and operates only in reference to, a judge's granting of a restraining order in favor of an identified, protected person, there is simply no room to suggest that such a person has received merely an incidental or indirect benefit. See ante, at 766 to 767. As one state court put it, domestic restraining order statutes identify with precision when, to whom, and under what circumstances police protection must be afforded. The legislative purpose in requiring the police to enforce individual restraining orders clearly is to protect the named persons for whose protection the order is issued, not to protect the community at large by general law enforcement activity. Nearing, 295 Oregon, at 712, 670 p. 2d.
That just
At
sounded like an Enderman teleporting
143.17.
outside.
Not only does the courts doubt about 16. I find it neither surprising nor telling, cf.
Okay.
ante, at 766, that the statute requires
Yeah,
the
I don't think
restraining
we're
order
winning.
to contain,
I
in
don't think we're gonna
capital
clutch this,
letters and
personally.
bold print, a notice
I think I'm about to give
informing
up on the run and
protected
just focus
persons
on
that they can
reading as we
demand or
finish this out.
request, respectively,
I think that's what I'm
civil
gonna
and
do.
criminal contempt
All right,
proceedings.
I'm calling it quits.
Section
This would be the time to generate a new world and see if I could do one in 5 minutes, but I
6803.5,
can't.
7.
So
While the
we'll leave this here.
legislature may have thought
I
that
will
these legal ream dies
keep
were
reading
not
and just kind of
popularly understood,
goof around on some
a
other stuff in the
person's
meantime.
right to demand or request police enforcement of a restraining order simply goes without saying given the nature of the order and its language. Indeed, for a holder of a restraining order who has read the order's emphatic language, it would likely come as quite a shock to learn that she has no right to demand enforcement in the event of a violation. To suggest that a protected person has no such right would posit a lacuna between a protected person's rights and an officer's duties, a result that would be hard to reconcile with the Colorado legislature's dual goals of putting an end to police indifference and empowering potential victims of domestic abuse. 17. See also Matthews v. Pickett County, 996 S.W., 2D 162, 165, 10. 1999. The order of protection in this case was not issued for the public's protection in general. The order of protection specifically identified Ms. Matthews and was issued solely for the purpose of protecting her. Cf. Azell v. Cockrells, 902 S. W. 2D 394, 403, Tennessee 1995. Statute prohibit ing drunk driving does not specify an individual but undertakes to protect the public in general from intoxicated drivers. Soros Shetty, 65 N. Y.
What?
2D,
Yeah.
at 469, 482 N. 2D, at 75, the protective order evinces a pre-incident. 545 US 2. Unit, 76 Uruguayan pesos, March 26, 08, 21:17 and 18 seconds, pages PGT, open. Cite as 545 U.S. 748, 2005. Stevens, J. Dissenting. 789. Whether Colorado's statute created an entitlement in a protected person failed to take seriously the purpose and nature of restraining orders, but it fails to account for the decisions by other state courts, see Supra, at 782 to 783, that recognize that such statutes and restraining orders create individual rights to police action. For given that Colorado law has quite clearly eliminated the police's discretion to deny enforcement, respondent is correct that she had much more than a unilateral expectation that the restraining order would be enforced. Rather, she had a legitimate claim of entitlement to enforcement. Roth, 408 U.S. at 577. Recognizing respondent's property interest in the enforcement of her restraining order is fully consistent with our precedent. This court has made clear that the property interests protected by procedural due process extend well beyond actual ownership of real estate, chattels, or money. ID, at 571 to 572. The types of interests protected as property are varied and, as often as not, intangible, relate ing to the whole domain of social and economic fact. Logan vs. Zimmerman Brush Company, 455 U.S., 422, 430, 1982. See also Perry vs. Sinderman, 408 U.S. 593, 601, 1972, p. Property interests subject to procedural due process. Protection are not limited by...
What page are we at now? 42 or 46. All right, let's speed this up. Get this wrapped up.
See also Perry vs. Sinderman, 408 U.S. 593, 601, 1972.
I'll go ahead and make this most of the screen because this is what we're paying attention to right now.
Protection are not limited by a few rigid, technical forms. Rather, property denotes a broad range of interests that are secured by existing rules or understandings. Thus, our cases have found property interests in a number of state-conferred benefits and services, including welfare benefits. Goldberg vs. Kelly, 397 U.S. 254,
Cool. All right.
1970.
Finishing it out.
Disability benefits. Matthews vs. Eldridge,
I'm sure if I have to lift this up though, I probably will.
319, 1976. Public Educatian. Goss vs. Lopez, 419 U.S. 565, 1975. Utility Services, Memphis Light, Gas and Water Dive EV, Craft, 436 U.S. 1, 1978. Government Employment, Cleveland BD, of Ed. v. Legislative and judicial determination that its holder should be accorded a reasonable degree of protection from a particular individual. 545 U.S. 2. Unit, 76 Uruguayan pesos, March 26, 08, 21:17 and 18 seconds, pages PGT, open. 790. Castle Rock v. Gonzales. Stevens, J. Dissenting. Loudermill, 470 U.S. 532, 1985. as well as in other entitlements that defy easy categorization. See, e.g., Bell vs. Burson, 402 U.S. 535, 1971. Due process requires
There
fair
we go.
procedures before a driver's license may be revoked pending the adjudication of an accident claim. Logan, 455 U.S. At 431, due process prohibits the arbitrary denial of a person's interest in adjudicating a claim before a state commission. Police enforcement of a restraining order is a government service that is no less concrete and no less valuable than other government services, such as education. Point 18. The relative.
I've been waiting for one of them to make this argument the entire document. Look at this. Police enforcement of a restraining order is a government service that is no less concrete and no less valuable than other government services, such as education. And so the question becomes, how is it that someone like me, who is a teacher, how is it that I can be held to a certain constitutional standard, which I believe is called FAPE, which is a free, appropriate public education? Look at this. I can pull this up right now. The right to a free, appropriate public education is an educational entitlement of all students in the United States who are identified as having a disability. So students with disabilities are allowed, they are entitled, in fact, to a free, appropriate public education. So free doesn't just mean like government, like money free. It does, but it also means like an unrestricted public education. That's appropriate to their needs. You can't have an extremely restrictive education. It needs to be appropriate for their needs and no more or no less, right? I, as a teacher, and mostly this is a civil right, as it says right here. Look at this. You actually can't see it. Let me adjust it. Look at this. FAPE is a civil right. Let me make sure you can see this whole thing as I keep going on about it. FAPE is a civil right rooted in the 14th Amendment, the same one we are considering here, where it's right to police enforcement if they're going to be present, and already giving you this shit. In education, FAPE is a civil right in the 14th Amendment, which requires schools to provide students with disabilities special education and related services at public expense, designed to prepare those students for the future. If I, as a teacher, can be part of an organization, that being a school, can provide an entitlement to a student per their civil rights in the 14th Amendment, how is it that a police officer is not obligated or able to create the entitlement to citizens to be protected and served? How is it that I can do my job without qualified immunity, and schools can continue existing without getting closed without qualified immunity, but police officers can't when it's a matter of life or death? That's stupid. That's stupid. That's insane. That FAPE is a civil right for special education students, where the organization that is a school has to provide it, and in fact, they will face legal penalty if they fail to provide this entitlement. But police officers get qualified immunity and aren't obligated or entitled or are not obligated to provide people this entitlement. It is not up to my discretion whether or not I, as a cog in the school-sized machine, provide students a free and appropriate public education. And in fact, if I were to consciously or even just accidentally for a long period of time so as to be nearly neglectful, if I were to take this free and appropriate public education civil right away from special education students in my classroom, I could be liable for that. I'm not sure if it's criminal or civilly liable, but I do not have qualifying immunity from neglecting the civil rights of my students. And the Supreme Court had an opportunity here to say that police enforcement of restraining orders in the cases of domestic violence is a civil right. It's insane that the Supreme Court would not say, yeah, that's a fucking civil right. If you're going to get a restraining order, that creates the expectation that the police will in fact restrain someone if they're trying to abuse you. And this lady called over and over and over for police to do something. They showed up, they ignored her, and then she called again and again and again. They kept ignoring her. And they took away what should have been a civil right. And the Supreme Court had the opportunity to make this a civil right, and they chose not to. If you are a patriotic American under the age of, how old am I? 26? If you are a patriotic young American under the age of 25, you have no right to talk about the supremacy of the West, of how incredible the West is, and how the West the West needs to be defended, and we're so incredible. You live in a country where it is not a civil right to be defended from your domestic abuser. That's not civilized. That's not supreme. That is not transcendental. You are not better than a savage. There's no gap. There's no protection. If it is not recognized that when a woman gets a restraining order for her abusive husband, that is a civil right to have it enforced and have her protected. Because the police cannot have a monopoly on justice and then make offerings to you in the form of a restraining order and then just not fucking enforce it. These cops face no consequences. But when teachers fuck up, when schools fuck this up, for students in the free, appropriate, and public education civil right, we face consequences. Teachers could be civilly or criminally liable, I'm not sure which, but one of them, and schools can get in trouble with the government for failing to do this. And yet our Supreme Court ruled that women don't have a right, that people don't have a right to be free of domestic abuse. One thing I want to tell you about, and maybe I'll be smart enough to pull it up somewhere, is that in the end of this documentary about, I believe, Jennifer Lenahan, who was Jennifer Gonzales. I believe her name was Jennifer, I believe. No, it was Jessica, wasn't it? Jessica. Yeah, Jessica Lenahan is her last name now. Over the 15 years she spent constantly fighting to have this be recognized and for something to be done, it ended up that the Supreme Court failed her. The American internal justice system failed her. So she went to a different counsel who evaluated her case, and they came to the conclusion that freedom from domestic abuse should become a human civil right. Because for some reason, that wasn't already a civil right. So progress was made. Like, something got better, things got better. But it just confounds me in the most insane way that a teacher can be obligated to provide students certain rights and entitlements without qualified immunity. But a police officer needs qualified immunity and to be allowed to be 100% discretionary in their enforcement. I don't know. You do not get to go around and talk about the incredulity of the West and America and democracy when you fail on this front so hard. At some point, you must ask yourself, when does dystopia become worse than anarchy? When does a failed state that has internalized corruption and injustice so horrifically become worse than just outright anarchy? And not even the cool kind, like the actual theory kind. I'm talking the pop culture misunderstanding. Like, at what point is the Wild West or Mad Max low-key better than living in a society where harm is legislated like this? Like, would you rather live in a world where it's legal to defend yourself, but the police don't exist? Because I might be into it. I might be into it. To live in a world where a woman can't be prosecuted for killing her psychotic husband, but the consequence is that there aren't cops. Yeah, but fuck it, ball. Like, that's literally better than the dystopia we currently live in. But don't get it twisted. Anarchism doesn't have to be that bad. Anarchy and the theory of decentralized community and minimal government, what used to be libertarianism, can be way fucking better. It's not chaos. But at some point, I'm tempted to think chaos is better than dystopia. Call me entitled. Yeah, I should fucking be. Humans should have rights. Our government is we do not exist to be afraid of our government. Our government should be afraid of us. and afraid and weighed down and responsible for the power we vest into them. Let's finish this document. Jesus. All right, here we were. This is where we were. Police enforcement of restraining order. Police enforcement of a restraining order is a government service that is no less concrete and no less valuable than other government services such as education. Jesus.
Ments that defy easy categorization. See, e.g., Bell versus Burson, 402 U.S. 535, 1971. Due process requires fair procedures before a driver's license may be revoked pending the adjudication of an accident claim. Logan, 455 U.S. at 431. Due process prohibits the arbitrary denial of a person's interest in adjudicating a claim before a state commission. Police enforcement of a restraining order is a government service that is no less concrete and no less valuable than other government services such as education. Point 18. The relative novelty of recognizing this type of property interest is explained by the relative novelty of the domestic violence statutes creating a mandatory arrest duty. Before this innovat ion, the unfettered discretion that characterized police enforcement defeated any citizen's legitimate claim of entitlement to this service. Novel or not, respondents claim F in strong support in the principles that underlie our due process jurisprudence. In this case, Colorado law guaranteed the provision of a certain service in certain defined circumstances to a certain class of beneficiaries, and respondent reasonably relied on that guarantee.
This is no different than the constitutional existence of a free and appropriate public education. They are the same thing, and they should have been treated the same.
Roth, I.T. is a purpose of the ancient institution of property to protect those claims upon which people rely in their daily lives, reliance that must not be arbitrarily undermined.
And again, the restraining order was a thing, a physical thing with a physical consequence that this woman fought for and was awarded and given. It was her property. Not that I love the concept of property. I don't. But it's just all contradiction. It's contradiction all the way down. It's horrible.
US at 577. Surely, if respondent had contracted with a private security firm to provide her and her daughters with protection from her husband, it would be apparent that she possessed a property interest in such a contract. Here,
Colorado I'm finally really getting what they're talking about with property interest. It's just taken forever. Yeah, a contract is a contract. A restraining order is a restraining order. It's a contract between a person and the police, where the police make a commitment to enforce the restraining order. Otherwise, it just wouldn't exist. So we've got a Schrodinger's restraining order. Either restraining orders exist and have to be enforced, or they don't have to be enforced, in which case they're just a piece of paper that never meant anything.
Comparable obligation and respondent, with restraining order in hand, justifiably relied on that undertaking.
Yeah, you would want a person to rely on that.
Is no less legitimate than the other claims our cases have upheld, and no less concrete than a hypothetical agreement with a private firm. Point 19. The fact that it is based on a statutory enactment and a judicial order entered for her special protection, rather than on a formal contract, does not provide a principled basis for refusing to consider it property worthy of constitutional protection.
Again, I do think the Constitution being written so as to not codify human rights is really stupid. Like, yes, we have the Bill of Rights, but we should codify human rights. It should be like, violating this right is illegal. The fact that we live in a country where this case could happen, and the approach they had to take involved the 14th Amendment and the right to property, instead of just saying it's a human right to not be subjected to domestic abuse. Like, how? I understand.
19. As the analogy to a private security contract demonstrates, a person's interest in police enforcement has some ascertainable monetary value, ante, at 766. C.F. Merrill, The Landscape of Constitutional Property, 86 Virginia L. Rev. 885, 964, n. 289, 2000, remarking, with regard to the property interest recognized in Goss versus Lopez, 419 U.S. 565, 1975. That any parent who has contemplated sending their children to private schools knows that public schooling has a monetary value. And while the analogy to a PR
reasonably educate, dude, me and John Paul Stevens and Ruth Bader Ginsburg are like this. Like, we share a fucking brain cell.
PRI Vate security contract need not be precise to be useful.
Except I have one brain cell in the community law and they have 30 billion.
Would point out that the court is likely incorrect in stating that private security guards could not have arrested the husband under the circumstances, see ante, at 766 to 767, and 12. Because the husband's ongoing abduction of the daughters would constitute a knowing violation of the restraining order, CN 13, supra, and therefore a crime under the statute, see section 18, 6803.5, 1, a PRI vate person who was at the scene and aware of the circumstances of the abduction would have authority to arrest. See section 16, 3.201, a person who is not a peace officer may arrest another person when any crime has been or is being committed by the arrested person in the presence of the person making the arrest. Our cases, of course, have never recognized any requirement that a property interest possess some ascertainable monetary value. Regardless, I would assume that respondent would have paid the police to arrest her husband if that had been possible, at the very least, the entitlement has a monetary value in that sense. 20. According to Justice Souter, respondent has asserted a property interest in merely a state-mandated process, ante, at 771, concur ring opinion, rather than in a state-mandated, substantive guarantee. 545 U.S. 2. Unit, 76 Uruguayan pesos, March 26, 08, 21:17 and 18 seconds, pages PGT, OPIN. 792. Castle Rock v. Gonzales. Stevens, J., dissenting. V. Because respondent had a property interest in the enforcement of the restraining order, state officials could not deprive her of that interest without observing fair procedures. 21. Her description of the police behavior in this case and the department's callous policy of failing to respond properly to reports of restraining order violations clearly al. Ibid. This misunderstands respondent's claim. Putting aside the inartful passage of respondent's brief that Justice Souter relies upon, ante, at 770, it is clear that respondent is in fact asserting a substantive interest in the enforcement of the restraining order. Brief for respondent 10. Enforcement of a restraining order is a tangible, substantive act. If an estranged husband violates a restraining order by abducting children, and the police succeed in enforcing the order, the person holding the restrain ing order has undeniably just received a substantive benefit. As in other procedural due process cases, respondent is arguing that the police officers failed to follow fair procedures in ascertaining whether the statutory criteria that trigger their obligation to provide enforcement, i.e., an outstand ing order plus probable cause that it is being violated, were satisfied in her case. Cf. Carey v. Piffus, 435 U.S. 247, 266-267, 1978, discussing analytic difference between the denial of fair process and the denial of the substantive benefit itself. It is Justice Souter, not respondent, who makes the mistake of collapsing the distinction between property protected and the process that protects it, ante, at 772. Justice Souter also errs in suggesting that respondent cannot have a property interest in enforcement because she would not be authorized to instruct the police to refrain from enforcement in the event of a violation. Ante, at 770. The right to insist on the provision of a service is separate from the right to refuse the service. For example, compulsory attendance laws deny minors the right to refuse to attend school. Nevertheless, we have recognized that minors have a property interest in public education and that school officials must therefore follow fair procedures when they seek to deprive minors of this valuable benefit through suspension.
Oh my
See
God, they understand basic shit about pre-existing precedent with other civil rights. For example, compulsory attendance laws deny minors the right to refuse to attend school. Nevertheless, we have recognized that minors have a property interest in public education, and that school officials must therefore follow fair procedures when they seek to deprive minors of this valuable benefit through suspension. How is it? Oh my God. What would I rather live in? Would I rather live in a society where it is hard to suspend students, but that means that violent and risky students are sometimes in schools and have to be gotten rid of slowly? Or would I rather live in a society where kids just get kicked the fuck out for any goddamn reason, and we just have swaths and on an ocean of children not getting educated and losing their right to education because they did something that pissed off a school? I would unfortunately still choose the one where the extreme students are hard to get rid of. I would also similarly choose to live in a world, if we're going to do this whole society thing, this whole government thing, this whole democracy, representative republic bullshit thing, if we're going to do that, then I'd like to live in a world where a policing organization, a police department, does not have the right to deprive you of enforcement while still saying they have a right to be the sole monopoly on the process of seeking justice. That doesn't make sense. I would rather it be that they have to do their jobs and we deal with the extremes and call them back, just like we do in schools right now. Jesus, I want a different thing to complain about. I don't want to complain about people hoping the police will save them and then ending up dead. I want to complain about, the cop couldn't let this off, but a judge just let it slide, so we're good. I'd rather complain about that. That seems a lot easier to reel in than this thing where you just kind of let them have no accountability whatsoever. God, I'm so happy I read the dissent. This is great.
565. In the end, Justice Souter overlooks the core purpose of procedural due process,
Ensuring
ensuring that a
citizens-
citizen's reasonable reliance is not frustrated by arbitrary government action. 21C Logan vs. Zimmerman Brush Company, 455 U.S. 422, 432, 1982. While the legislature may elect not to confer a property interest, it may not constitutionally authorize the deprivation of such an interest, once conferred, without appropriate procedural safeguards. 545 U.S. 2. Unit, 76 Uruguayan pesos, March 26, 08, 2117 and 18 seconds, pages PGT, OPIN. Cite as 545 U.S. 748, 2005. Stevens, J., dissenting. 793. Leges a due process violation. At the very least, due process requires that the relevant state decision-maker listen to the claimant and then apply the relevant criteria in reaching his decision. Point 22. The failure to observe these minimal procedural safeguards creates an unacceptable risk of arbitrary and erroneous deprivation. S. Matthews, for 24 U.S. at 335. Accord ing to respondent's complaint, which we must construe liberally at this early stage in the litigation. See Swierkiewicz vs. Sorima N. 534 U.S. 506, 514, 2002. The process she was afforded by the police constituted nothing more than a sham or a pretense. Joint Anti-Fascist Refugee Com v. McGrath, 341 U.S. 123, 164, 1951, Frankfurter, J., concurring. Accordingly, I respectfully dissent. 22 C. Fuentes vs. Shevin, 407 U.S. 67, 81, 1972, W. When a person has an opportunity to speak up in his own defense, and when the state must listen to what he has to say, substantively unfair and simply mistaken deprivations of property interests can be prevented. Emphasis added. Bell vs. Burson, 402 U.S. 535, 542, 1971. It is a proposition which hardly seems to need explication that a hearing which excludes consideration of an element essential to the decision whether licenses of the nature here involved shall be suspended does not meet the standard of due process. Goldberg vs. Kelly, 397 U.S. 254, 271, 1970. D. He decision-maker's conclusion as to a recipient's eligibility must rest solely on the legal rules and evidence adduced at the hearing. Cf. Ibid. O. F. Course. An impartial decision-maker is essential.
Okay. And that is the end of this document. And an opportunity for quick final thoughts. What have I learned? Let's go back up to the very top. What have I learned? I have learned that the concept people spoke to me about of, how about I set the window here? What have I learned? I have learned that in essence, the United States is a joke of a country because we have not codified human rights. We have only codified constitutional civil rights. And it is a certain fact, according to not just this one Supreme Court case, but many Supreme Court cases, that the police have no duty to protect or serve American citizens. They only stand the obligation to not interfere with our civil rights in accordance with completing their work. They have no obligation to act and serve and protect you from other people, even when those people are committing crimes. The police, constitutionally, legally, are not your friends. And they're not there to protect you. They're not there to serve you. They're there to investigate reasonable suspicion of the committing or the prior committing of a crime in order to develop probable cause to believe a crime has been committed, and then seek to arrest people if they are on scene or get arrest warrants if they are not. That's their job. That is their only job. Their job is to, I don't really know, actually. Like, that's the thing, is like what I've described their gameplay loop, but I can't comprehend what that gameplay loop has to do with you and the taxes I pay for those police to exist. They don't do anything that you would expect them to, given that we experience taxation for their existence. The police are not your friends, and frankly, the police, I don't know. I don't even know what to say. What are they? They're nothing I ever thought they were growing up. They're nothing I feel like I've ever been told in mainstream media. Yeah, I know what it's like to be a random poor kid that probably had to break the law in a few cases growing up just to get by, because I did. And so, you know, the idea of a power-hungry cop that can't be trusted is not new to me. I grew up with that as a child. I was not so sheltered that I didn't know that. But I at the very least thought that cops, like, go after bad guys because they have to. Just like teachers have to teach because they have to. But they don't. They have no obligation to actually serve or protect people. And we don't even have legal routes by which to argue we have an obligation to be protected by the police force we pay taxes to exist. I don't know. Like, you're watching like the death of the American myth live, and like, I'm already pretty far gone. I mean, I'm the dude that fucking made the ACAB video several months ago, before I had had negative experiences personally and anecdotally with police. I already came to that conclusion, sure, by watching how they do their jobs, by understanding their gameplay loop, by watching body cams and seeing their conduct. But it's one thing to recognize that they're trained bad and that's why they keep killing people. And it's another thing to know that, like, they are simply morally, the pathway for police to do their job correctly has been bulldozed down. It has been bulldozed. And the easiest route is to do unethical and illegal and fucked up shit instead. And the Supreme Court has just bulldozed all opportunities to hold police accountable down. And they also have qualified immunity. Yeah. At what point is dystopia worse than anarchy? I'd say it's about this point. When in an attempt to do its job correctly, your government has become so corrupt, so twisted, and so out of touch with normal people that, like, buying the necessary things to protect yourself becomes more favorable than having any hope that your government will do anything right by you in the first place. It's worth thinking about. All right, that's the stream. Goodbye. Take care.